What's up, guys? Can you hear me? I hope so. We may have, I don't want to jinx it by saying it, but fix the microphone issue. I hope that everybody is doing well tonight. It is the Friday after Thanksgiving, so I'm assuming that most of you had the same dinner that you had last night in sandwich format. Is that how that works? Let me know in the chat what you have for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. BLT, Courtney, yes. Good choice, solid choice. I prepped and like cleaned up after making dinner this afternoon already, which I feel pretty proud of. Just say that. Um, but you thought about turkey. Well, I can understand that as well. Also, just know when you know where something is, but you don't, and you need it. Yeah, that's what I'm going through right now too. Just swore something was somewhere and then it's not there. We have to find it. Let's see. Thanks so much, Nancy. I hope you're doing well. Vicky was first. I changed the comment from first for Vicky because there was a mini, I don't even know. I was literally busy looking for something, so I felt like I was saved by the bell for a couple minutes with that chase, whatever it ended up becoming. I don't even know if the guys are live still. It was just time for us to get going. Anyways, we do have some court to watch this evening. You're not feeling well today, Nancy? I'm sorry to hear that. I didn't sleep very well last night, but we're we've been very productive today, so I'm quite happy about that. I have had this is my second extra large coffee, so perhaps that's helping. I don't know. We are almost at 50 members, which is just exciting and so happy. Oh, and happy birthday. I'm sorry. Happy birthday to Mayor and Sashina. I forgot that I didn't forget. I remembered, but I just momentarily forgot that it is indeed birthday for Mayor and Sashina. And there's somebody else too, like Alex MacTac, who might come in here once in a while as well. Anybody else, let me know. Happy birthday, guys. Love you, love you, love you. Hey, T Rex. Hey, I like the number. Thanks for joining us, T Rex. I appreciate it. Happy Friday, Friday. What did you, T Rex? People have been missing you, Miss Lisa especially. Um, yeah, and Mayor and Sashina. Seriously, is Sashina here? I know she had a premiere of her channel. If you want to give Sashina a birthday gift that is free, super free, go ahead and go to my channel and scroll down and look where it says my friends. And Sashina's channel is linked because she's an author. Okay. And also has sheep. Pretty sure they're sheep. We talk about this every time. I think they're goats, but then I correct myself to be sheep, but then I doubt myself and think they're goats again. They're sheep. I'm pretty sure they're sheep. Yeah. I'm going with sheep. Final answer, sheep. Uh anyways, like I said, Sashina has a channel and it is a free birthday gift for you to go subscribe to her. Let's see how many people we can get subscribed. Uh Also, I didn't see any, well, I saw a few people tell me about turkey sandwiches. Is that all you have on Thanksgiving, post Thanksgiving Day? What would you call it? See, in Canada we call it Tuesday because Thanksgiving's always on a Monday. But what would you call it? The day after Thanksgiving? The Thanksgiving Day hangover day? Shit, I almost got it. Look at that. Thanks, T-Rex. Wow, that was delayed. That must have been like, wow, an hour? Or no, sorry, a minute. Look at how, that's how my brain works. An hour. That was an hour. Oh my God. Anyways, we should probably get watching some court. Um, I think so. We have some family law. I know that's not everybody's jam, but it is my jam. 'Cause I love other people's drama. I don't like drama myself, but I like other people's drama. This is the self-represented docket from Cowlitz County. I think that's Washington. That's very glossy. Think that's Washington. And let's see. I already downloaded. Oh, it's this judge. I don't think we like her that much, but I think we'll give her a try. Um, oh, look at that transition. Please also tell me if my audio is fucked up today at all, because oh, I feel like we might be, if I'm choppy right now as opposed to being like pretty good right now, then I have not fixed the problem. But if I'm still solid and steady for audio, then I may have actually fixed the problem of playing audio while talking. Also, we have 1000% seen this guy before, probably a month ago or 2 months ago. I don't know, but we've seen the guy glasses before for sure.
All right. Good morning. This is Commissioner Jill Carmy. Can you hear me?
Yes, I can.
Yeah.
Okay, great. Apologies for the late start on this docket. I had another courtroom docket go over a little bit. So we're getting started here just a few minutes late. Thank you everyone for your patience. We have, I think, just 5 cases on today. Some of those have multiple issues though. So I'm going to try and take what I think might be shorter matters first. First up, number 1 on our docket, 14-3005100. I see Christopher Olson present, and I believe Tiffany is.
I'm here.
Steinweg is there. Thank you. What I was looking for was an update on the mediation that was supposed to take place yesterday. What can the parties tell me?
What happened yesterday was we came to an agreement, not on a permanent basis, but temporary until December 31.
Okay.
And that would be he would get him every other weekend, but his mom would supervise.
Okay. Did you all want that to be a part of a temporary parenting plan, or are you both just asking for a bench order on that agreement through December 31st?
My concern is that the mediator said that if we do this and we don't come to court or have a final parenting plan in place, then it's going to go back to the original order, and I don't want to go there.
Okay, so I could give you 2 options. One, if the only thing needing to get done right now through December 31st is a change in that visitation to supervised visitation and specifics regarding when that occurs, I can do that in a bench order for you today, and then we could set up a follow-up review date to work on final orders. Or if you want to present me with a temporary parenting plan that you both sign and agree to, I could put you back on a docket next week or in 2 weeks, and I can sign off on that order. I don't know if you worked on a temporary order in mediation. I just don't have the document.
It was just verbal, and then she said ultimately you would make your decision today.
Okay. So, well, what I'm going to do today then is first, Ms. Steinweg, tell me the language that you 2 have agreed to. I'll ask Mr. Olson if he's in agreement to that. We'll put that in a bench order, and then we can certainly set another date. But I don't create the orders. You all create the orders and present them to me for review. So if you're wanting an actual final parenting plan, either we set that for trial, or if it's an agreed order, you all prepare that and present it to me.
Okay, so what about the show cause hearing that we discussed before? What is that?
We can get to that in a minute. Can you give me
Okay.
the language that you both have agreed to? And
Yes.
then Mr. Olson, I'll come to you.
So it would be every other weekend, Friday to Sunday from 6 p.m. to 6 p.m.
Friday to Sunday. Okay.
And that would be a supervised visit at Chris's mom's house, which is Kay Gunter. I don't know if you need her name.
Yeah. Can you spell her name for me?
Kay.
Okay.
And last name is Gunter.
Okay. So it's at her home.
Yes.
And she must be present the entire time.
Her or her husband.
Okay. And is Mr. Olson to be present the entire time?
No.
Okay, so he can come and go from that home during visitation. Okay. Okay, anything else that was agreed to?
The other thing was for winter break, we split the break. So Kay would keep him from
How many judges do we know that would be calling somebody out for smoking like that in the chat? Or not in the chat. I don't give a fuck if you smoke in the chat. Go ahead and smoke in the chat, folks. But if you're in court, please don't smoke.
December 25th at noon till January 1 at 6 p.m.
6 p.m. And again, that would be with Kay.
Yes.
Okay. And that'll just be winter break for 2023.
Yeah.
Okay. Okay. So is there anything else?
No, just that he's not able to leave with him. It needs to be supervised.
All right. Mr. Olson, thank you for being here. Is that your agreement and understanding at this time regarding temporary visitation? Oh, you're muted, sir.
Sorry about that.
It's okay.
No, absolutely not. I don't know why I need to be supervised visits. I know that you did get the hair follicle back, and it went back to, well, I got clean on July 22nd. And that's when I got into treatment, and I've been ever since. And I provided with all my treatment UAs that I've taken at treatment. I've provided like what I have done up to this point, but like nobody's, I feel like, acknowledging that I took care of getting clean months ago. So I don't know. No, I absolutely do not agree to that. And every other weekend. So we're still back at ground zero, except for I've done quite a bit of stuff to better my life and my family's life, with the outpatient and with mental health, and I'm feeling pretty good, except for all this. So what now?
Can I say something?
Go ahead. And then I'm going to make my ruling.
Okay. So yesterday we agreed to all this through the mediator. Is that not?
You guys.
Hey, Mr. Olson, no, thank you. This is her turn. I will come back to you. Go ahead.
Okay.
He even sent me an email. I didn't print it out, but stating that he was in agreement to that. So I don't understand. I don't know. Let's just move forward.
Yep. Mr. Olson, what did you want to say?
Nothing. You've already, go ahead and make your ruling. Okay. I don't know what to say. Did you not get like the paperwork I turned in or anything.
What paperwork?
Well, I dropped off from my
API Community Observer, please mute. We're hearing you in the middle of another case. Go ahead, Mr. Olson. I apologize.
I turned in to the courts yesterday after the mediation from my treatment facility, a letter from the head lady over there with a copy of all my UAs, and she explained that the Suboxone and the methadone that's on there are prescribed, and then they switched them though because one of them was giving me stomach problems, and so when you look at my UA, it says positive, but it's positive for my prescribed medication. And also I got a letter from my counselor from mental health.
Okay. So if you turned those things in yesterday, as you've been in this court enough to know, it wouldn't be available for my review today. It takes several days for it to get scanned into the system. You would have to leave a hard copy, bench copy, if you want me to see it 24 hours of filing. So I don't have that. What I do have today is a hair follicle test that is positive for things other than what would be prescribed medication. I assume that you have seen that as well, sir.
Yes.
Okay.
Do you know when that is from?
I have the date in front of me, date collected October 19, 2023.
And so that goes back to when I was using. But like I said, up until July is when
This is when I mean, is he clean? Is he residually not clean? These are the questions that we have. Welcome, everybody that is just joining us. Please go ahead and hit the like button, subscribe. That helps me out so much. Make a comment on an old video. Oh, love it when you do that. Or say happy birthday to Sashina or Mayor or anybody else who comes forward with a birthday. Also, what is her calendar? I'm looking at my one screen, I'm looking at my other screen. To me, it looks like legs in a row that have I don't know, ribbons wrapped around them. What is behind Miss Tiffany in her calendar? That is the question we have. He was dirty last time, and he didn't put his evidence in on time, Lisa B. That's a really good point. These are rules of the court, but lucky for him, unlucky for the child. I don't know which. This is the family law self-represented docket. I put the emphasis on family. I should have put the emphasis on self-represented, aka pro se, aka not a lawyer, baby, docket. So we are only hearing people that have no fucking clue what they're doing. I'll just say that.
got clean. So I guess the hair follicle, I'm told, can go way back if the more money you spend on it.
Okay.
So I don't know.
Okay. Here's going to be my ruling today. With this recent October 19th, 2023 hair follicle testing, given the comments of the parties, I have no notes for mediation, but I think that the proposed language from Ms. Johnson is more than beneficial to you, Mr. Olson. Based on the hair follicle testing, I had revoked visitation until we got more documentation and information in. I think that the proposal from Ms. Johnson is very appropriate under the circumstances. I am going to issue that temporary bench order. I will get that issued today. It will specifically state that during visitation, your mother, Kay, is to be present at all times. You are not to take the child out of her home unless she is with you. So she or her husband need to be present for supervised visitation. I will set a review date so that we can review the documents you filed yesterday. The other outstanding issue was that Ms. Steinwig had filed a motion in order for default. I had initially denied that because Mr. Johnson, or excuse me, Mr. Olson, you did appear. You did provide a declaration affidavit regarding your position regarding a final parenting plan. In this case, the problem I have is you haven't really filed a formal response. But I am going to find that it's enough to avoid a default order and move this case on to the merits. So I am going to deny the default. I am going to issue that bench order. Ms. Steinwig, what else are you asking for the court today before we set a review date? And I'll just let you know at this point then, since it sounds like mediation was not successful, your options would be to get onto our trial assignment docket and get this case scheduled for either a mandatory settlement conference or a trial.
I would definitely like to do the mandatory settlement conference.
Okay.
Because they scheduled us for another mediation, but if it's pointless if we're gonna go in, agree, and then come back and it's gonna be totally different the next day.
I would agree with that. So let's get you all, I'm gonna issue this bench order. Let's set you for a trial assignment docket, which we have those every Wednesday at 1 o'clock. At that time, you will be scheduled in front of a judge that is not me for a mandatory settlement conference. Probably, if I had a guess, it would be early next year, 2024. I doubt you'll have any December dates.
So, but this order will be current until we go to that, correct?
Yeah, and what I'm going to do is set a review date before December 31st on this docket with me so that we can review how that new visitation is going.
Okay.
So what is the first, would you all be available? Well, is trial assignment open next Wednesday?
Yes.
Okay. Would you all be available next Wednesday at 1 o'clock to log on for trial assignment docket to get a mandatory settlement conference date?
Yes, I am.
Mr. Olson, are you available?
Yes.
Okay, so November 29, 2023 at 1 o'clock. We'll get you scheduled for a mandatory settlement conference. Then let's get you a new date. Let's get you as close to the 31st. We could do December 27 at 9 a.m. back on this docket to review the visitation schedule. If for some reason you issues come up from either party, you are free to renote it back on this docket for review if you need to. But it would need 21 days notice to the other party. So December 27th is probably pretty close to where you'd end up anyway.
Okay.
Okay. Okay, I will get the bench order issued. Anything else from the parties today?
No, thank you.
Okay, Mr. Olson, any questions for the court?
Nope.
All right, thank you, sir. You're both free to log out. Okay, number 3 on our docket, 223-0025-408, Alexandria Vaughn and Zachary Kiyoshi. I believe Ms. Fellows is present with us.
Yes, Your Honor.
Okay. I'm just going to get into my digital file here.
My digital file
So,
here.
a question I have for the parties. I know we did change visitation at our last appearance. How is that going?
Who do you want to hear from first?
Ms. Vaughn, go ahead.
Okay, so the very first week of visits, I obviously had a lot of anxiety about him being with his father unsupervised for the first time, and he had provided a kind of vague itinerary, but at pickup or drop off, I should say, I asked him to specify locations, like places, rather than a park kind of thing. And he had said he would be at the park across from the Youth and Family Link building, which is Vandercook Park, or not Vandercook, Victoria Freeman Park, I believe. So when he was supposed to be there, I had called my sister who lives across the street and asked her to check outside to see if Corey was out there with his dad.
Okay, that's a little creepy, right? That's a little creepy. A little creepy. Like, I get overprotective mom. I get divorced mom. I don't know how old the kid is here. Let's say 3 and under, I'm going to allow it. 3 and over, not fair game. The likelihood of you having a family member living across the street from the visitation place where your kid is doing visitation is so slim that this is not a standard. This is not the way that it should be. Right? Am I wrong about that? Or also, Sashina, happy birthday. I don't know if you heard me earlier, but happy birthday to you.
And she said that no one was there. That proceeded for the entirety of the visit. He never showed up at that park like he was supposed to be at. When I picked my son up, I asked him what he did with daddy today, and he had said, "No, I don't want to tell you, mommy." My kid has never done that.
Okay, well, hold on.
After
Just a second. Hold on, ma'am, just real quick. Given the age of this child, we're walking into child hearsay. So I'm not going to accept it. You haven't, hold on. You haven't filed a declaration about any of this.
So I called back.
Well, ma'am, hold on. I'm trying to help you out here. I'm not going to
Shut
hear
up,
what your
bitch.
child told you. That is child hearsay. I'm not taking that into account today.
Okay, he did tell me they went to a park, just not the one he was supposed to be at.
Okay, ma'am. First of all, I have square earrings on. I'm speaking of the judge right now. I have square earrings on. Also, nobody's asked me to sing, so I'm not going to offer to sing. If somebody wants me to sing, I will. You know that I will, but I don't sing well, so I implore you.
Okay. All right. Hold on, Ms. Vaughn. I'm going to come back to you. I'm going to tell you when it's your turn to talk again, okay? I'm just going to be very specific. I did not put in my order that every second of the visit he had to tell you exactly where he was. All I wrote was that he had to give you a proposed itinerary. So other than your concern that you don't know every second of every minute where the child is at, how is visitation going?
I can't tell you. Beth was supposed to be doing drop-ins, and as far as I'm aware, she has not done any. So I don't know.
Okay. Mr. Kiyoshi, how are visitations going from your perspective?
They're going good, Your Honor. It takes me an hour to drive down, so I try to get there early to maximize the use of the 2 hours, and then have them back before. I try to have them back before 1 o'clock. But other than that, visits are good. There's only so much to do, and the weather's getting cold and wet. So we've been doing a lot of things indoors, and there's not a whole lot of kid-friendly things to do indoors. Between 11 a.m. and 1 a.m. and 1 p.m. So I did talk to me and Beth Fellows had emailed each other about extending the time, and then me being able to take him out of Cowlitz County to be able to do more things because it is getting wet, and I can't take him to the park every time I see him because of the weather.
Ms. Vaughn, we had a hearing actually on this matter October 25th, and you weren't present. What happened?
I was never given notice that we had a hearing.
Well, Mr. Kiyoshi and Ms. Fellows were present, and it was in my order. And we actually set it at the September 27th hearing.
I was here that hearing then. I've never missed a hearing.
That's not what my notes show.
What day
Ms.
was
Fellows?
25th.
I'll tell you.
Ms. Fellows, what's your take on our current review of visitation and the changes we've made?
So at this point, by all accounts, it sounds like it's going well. I have not done a drop-in. I actually had planned on doing one last week, but didn't realize that Dad was on vacation, so there wasn't a visit last week. But it seems like it's going well, and his itinerary was a little bit vague, and so I did email him and ask him to be more specific, and he has since then. So I haven't had any issues with that. Regarding compliance and services, I did get a compliance letter from his DV treatment provider. It's dated November 7th, says that he is in compliance. He has completed his parenting program as well. So there's no issues about that. So at this point in time, I did email the dad. I did reach out to him last week asking what he thought would be logical and reasonable.
We'll see what's happening here. I have seen this dad before. He wants to be involved. This mom does seem incredibly disinterested in everybody else's commentary or comments. I don't know. But Dana, you're right. If there is DV involved, you understand being a bit neurotic. But I mean, I don't know. Also, Nancy is literally smoking. She's making me want to roll a joint right now, which I will do shortly. Also, hi, Colin. How are you?
As a next step for visitation, and he did respond, and he gave me, a good response. He does want like an 8-hour visitation. He wants to be able to go to his home area of Olympia, and he really wants to take Corey home. But I'm not comfortable with that because I have not yet done a home visit. We weren't at that point where I needed to do that. So after emailing with him, emailing mom, thinking about where we are, trying to be very logical about the next step, I let both parties know in an email yesterday or last evening that I would like to increase the visitation to 6 hours, go from 11 a.m. to 5 p.m., that he can go out of Cowlitz County, but not to his home because I haven't done the home visit yet. The visit should remain only with him and his son because we're still working on the father-son relationship and bond. Continue doing the itinerary on Monday on Our Family Wizard. And that
Colin, I read some of the comments from our live the other day. I am not sure that you read the same comments that I did. Well, let's say the people here love me, not everywhere else, but it's a bigger audience. But of course, I'm not afraid of that. So of course, I'll be happy to go on anytime and be the Karen to your Colin, I guess. Um, this girl is not happy. She does not like to hear the friend of the court say this at all, and she is upset. Let's say that.
he transports. And I know that he really would like to have a meeting at the halfway point so he doesn't have to transport so far. But given that this is a day visit for 6 hours, I am still at the point where he should be fully responsible for the transportation.
Is a 6-hour day visit on a Tuesday something that Mr. Kiyoshi you can do with your work schedule?
Yes, I'm off all day Tuesday, so that would work. Like Miss Beth Fellows was saying, I just was trying to see if we could meet halfway, so I'm not driving an hour. I leave an hour and a half early just in case traffic jams up because it is I-5. And then another thing we talked about was the father-son relationship. My only concern with that is we've done the supervised visits. I've turned in notes from the supervised visits, and it shows that me and my son have a good relationship. I don't understand why it still needs to be just me and him. I understand not bringing them home until the home visit is made by Miss Fellows, but the fact, like, I can't even take my son to go on the play date with his cousins at a park away from home. It's not going to be in this house, at a park away from home. I don't understand why I can't start introducing him to my side of the family. And they showed up to his birthday party, which was supervised by Parents Place. He had a good time there. There were no issues. I don't understand where he's going to get overwhelmed by family is coming from. I get staying away from home. Why can't he meet his cousins at the park and play for an hour or two?
And Mr. Kiyoshi, you reside in Olympia?
Yes, ma'am.
Okay. All right. Ms. Vaughn, I am inclined to increase visitation to the 6 hours. I will talk about location. I am going to, at this time, decline for child to be taken to father's home, but will 6 hours from 11 a.m. to 5 p.m. work for the child's schedule?
It does interfere with his nap schedule, which he goes down between 4 and 5 p.m. So I had messaged Beth back saying 4, maybe 5 hours would be easier to manage with his routine than 6.
Mr. Kiyoshi, would 10 to 4 work for you?
I'm asking for 8 hours, and it keeps getting cut down.
Okay.
Yeah, I'm his father. Yes, I understand if he needs a nap.
I'm giving you, sir, we're increasing from supervised to 2 hours unsupervised to now 6 hours unsupervised.
Yes,
so I'm asking you first if 10 a.m. to 4 p.m. works.
Yes, yeah, that
Okay.
works.
So I am going to issue a bench order that increases unsupervised visitation from 10 a.m. to 4 p.m. on Tuesday. I will increase where he can go. So I'm not sure the timing really works out for him to be taken back to Thurston County. My preference would be that any indoor playtime, which it seems like that's the big concern for winter, certainly can be accomplished in Cowlitz, Clark, or Lewis counties, which are the adjoining counties to Cowlitz. So I think for right now, that is appropriate. It keeps child close to home. Then you're not driving an hour and a half back to Thurston. I'm not saying we don't get there eventually, especially after a home visit, but then this is at least a start, gives you more options for indoor play, especially in Clark County. I'm still going to have you provide the itinerary to Ms. Fellows and Ms. Vaughn. I will allow in public locations like indoor play areas and outdoor parks for cousins to be present for these visits. I do think that's appropriate at this time. I take into account that he's fully completed the parenting program and that he's in full compliance with his DV program at this time. Anything else, Ms. Fellows, that we need to address in a new order from your perspective until we meet again?
Not that I can think of. My understanding was that mom went in the morning on Tuesdays. So I just want to make sure that she's able to get Corey to the drop-off point in the mornings.
Are you able to get the child to the drop-off location by 10 a.m. on Tuesdays?
I do have therapy. I'm being treated for PTSD from 9 to 10 a.m. every Tuesday. So it will interfere with that.
PM or AM?
AM, 9 to 10 a.m.
Okay. Well, then I think we just have to go back to 11 to 5. I understand that that's going to probably interfere somewhat with a change in nap time, but I think that's just where we have to be at to balance the interests of Mr. Kiyoshi, child and mom. So we'll do the 11 a.m. to 5 p.m. on Tuesdays. Let's set a review date for this. How far out do the parties want to go?
I don't see a reason to change from this until he's completed his DV classes.
Well, my preference would be we set something after drop-in visitation has been done by Ms. Fellows and a home visit. So maybe I'll ask Ms. Fellows, should we be looking into January for a review date to get both of those things done?
Yes, that's what I would prefer.
Okay. And then in January, are we still, yeah, we'll still be at 9 a.m. on Wednesdays. Okay. What if we set this to January 17? So it gives parties about 2 months to get all of those things done. And I would, if the parties are going to argue for or against a change in this, it would be really helpful to have declarations or other materials rather than just coming to, so I can read those ahead of time, rather than just coming to court and telling me things that I don't have any documentation to support, okay? Oh, okay. So January 17, 9 a.m. And it will, for Ms. Fellows, you may already know this, it'll be in front of Judge Evans starting in January.
Yes, Your Honor.
Okay, great.
So is the bench order that you're going to write, is it going to be about the adjoining counties? So Cowlitz and then adjoining Clark and Lewis?
Yes, I'm going to include that those visitations can include Cowlitz, Clark, and Lewis.
Okay.
Okay, anything else we need to do today?
So can anybody tell me what the hearing in October was supposed to be about? I have our bench order from September and it says our next review is November 22nd. So I have no clue what that was supposed to be for.
I have a review date in the bench order as October 25th, 2023.
Mine says
I believe, Your Honor, I think what had happened is you had set the review date for today, but when you wrote the bench order, you put in that October 25th date, I believe is what happened. And so I knew about it. Apparently the dad did, but the mom did not. I think it was mainly because in that September hearing, it was not announced that there was the October hearing.
Okay. So Ms. Vaughn, it wasn't a bench order. Mr. Kiyoshi was present. Ms. Fellows was present. We did note that you weren't present and we took no action and struck the matter and moved it to November 22nd today. So nothing was done, but there was a hearing.
Okay, and then the only other thing we had talked about the last hearing that didn't get brought up today was him getting my late father's mugs to me. He still has not done that.
Mr. Kiyoshi, I do remember talking about some of those personal belongings. Where are you at with that?
I can't find them, and I'm not, in all honesty, I'm not here for mugs. I'm here for my son. I don't know where her mugs are. She packed up, she moved out. I'm not going to be responsible for her mugs.
Okay, well,
here's the thing. It doesn't fucking matter what you want to be responsible for, sir. If you were told in a previous hearing to give her her fucking mugs, you better have given her her fucking mugs. Wow. Wow.
this is a petition for dissolution. As part of that, personal property is at issue. So we'll have to leave that as a contested issue for trial. And certainly Ms. Vaughn can make any requests about replacement value of those items if you have lost them. So I don't love your response, sir. It's a little bit off-putting, to be honest.
Yes, Your Honor.
She does have the absolute right to ask about her personal property in a dissolution proceeding.
Yeah, I understand that.
So saying that you're not here for that is not okay.
Yes, Your Honor.
So we'll leave that as a contested issue when this matter goes to trial. Again, Ms. Vaughn, you'll be able to ask for those items. If they're not able to be found, you can ask for the value of them. And I understand there's some sentimental value there.
Yeah.
Okay. All right. Thank you both. We'll see you back on January 17th.
Thank you.
Your Honor.
Okay. Number 4 on the docket, Westleen v. Westleen 22300276608. Do I have Nancy Westleen and Denzel Westleen?
Yes, ma'am. You have me. Can you hear me?
Yes, we can hear you. Thank you.
Okay.
It looks like we were waiting maybe on signature of documents.
Yes, ma'am. It's a 401k that he had, and LPL, they're not coming through with what they're supposed to do.
So that has not been accomplished. Mr.
No, as far as I know.
Wesley, what can you tell me? My notes from last time indicate she needed to sign some documents and then the transfer could be completed. You're muted, Mr. Westleen.
There we go. I just called my financial advisor, and he was trying to find out this morning some information to give you about what's going on. And as far as I can tell, we're waiting on signed documents from LPL and Nancy's financial advisor to send to Equitable. They're waiting for the initiation of this transfer of money, and the holdup right now is Nancy's financial advisor's been on vacation for the last 2 weeks, and so it'll be next Tuesday before I will be able to talk to somebody about getting that signature forwarded to Equitable.
Ms. Westleen, does that sound correct to you, or do you dispute what Mr. Westleen is
Kind of
saying?
in the dark. I thought we already did everything we supposed to do.
Hold on a second. Ms. Westleen, I know you're on Zoom, but you are in a courtroom. You cannot be smoking
Okay,
during
sorry.
your court case.
Sorry. But yeah, as far as I knew, everything was ready. And it was a holdup with LPL, not my financial worker.
Have you talked to your financial advisor and signed paperwork to the best of your understanding?
As far as I know, yes, ma'am.
Okay. Well, it's hard for me to know without this got a he said, she said matter. I don't know. Mr. Westleen, honestly, you've kind of been telling me the same story for a long, long time now. And what I dislike is when we give you a month to get something done, and then the day before the hearing, you're reaching out to your financial advisor to get a document to me for today. That doesn't help me. So I am going to give you guys another review date. Mr. Westleen, this is a contempt motion against you. So you can't just sit back and wait for Ms. Westleen or someone on her behalf to do something. You need to,
Your Honor.
Hold on a second, I'm not done. You need to proactively be the person to shuffle this through and get it done. This is on you. This is your account. So you have to get this done. If, as you're telling me, there's documentation that Ms. Westleen needs to do something and isn't getting it done, then get me that documentation. But I find that hard to believe without any documentation in the file right now to suggest that. Go ahead, Mr. Westleen. What do you want the court to know?
I just want the court to know that I have been proactive. I've called Equitable several times, and I don't know the number to LPL, but I have been trying to get a hold of her financial advisor, and Um, as far as I know, they got the message that this paperwork needs to be filled out, but so far they haven't come through with it. I've been waiting. My I don't have any money to live off of right now. My accounts froze up because of the whole thing. So I've been doing everything that I can to get to where I can make, have money to live off of.
So here's going to be my ruling today. So we've been here several times trying to get this done. The decree of dissolution incorporating this requirement was entered into on January 6th, 2023. So we're approaching a year. I find that unacceptable. We have got to get this done before the end of the year. I am going to set this out 30 days to December. We'll have docket on the 20th. December 20th at 9 a.m. Does that sound right? Yes. Okay. We're going to set you to December 20th at 9 a.m. I want to know that this got done, but Mr. Westling, that gives you a little less than 30 days to really push this through. And if it's something that Ms. Westling still needs to do, then you or your financial advisor need to notify her or her financial advisor, because she's unaware of anything else that needs to be done to get this accomplished. So I'm giving that little bit of time for this to get done. But on December 20th, that'll be 11 months into this process. And I will consider sanctions at that time under the contempt motion if we don't either have it completed, or I have documents from financial advisors telling me we're getting real close, we've made substantial steps, or we're waiting on Ms. Westling's signature. So if it's not done, I need one of those two things in my file before the 20th, okay?
Okay. One more thing, there was money coming from two accounts, one from Equitable and the other one from LPL.
Okay.
And the one from LPL, the smaller one, has been completed and was put into her account.
And I
So
think
it's
that
like
was
halfway there.
that was done previously, right? I think we had already.
No, it hadn't been. Just this week.
Oh, okay. Okay.
It went through.
And how much was that transfer?
It was I got a paper. It said 21,000 some change.
Okay. Ms. Westling, did you receive that amount in the last week or so?
I was told. I haven't went down and talked to my financial worker since we went down and signed a bunch of papers. So.
Okay.
And he also brought some over for me to sign so that he could get that other money.
Okay. That's all really positive news. I appreciate that, Mr. Westling. We'll see you back on December 20th, and hopefully we've put the last piece of the puzzle into place on this, and you all don't have to come back here in 2024. Okay.
That would be great.
Okay. Yeah. Thank you both.
Thank you.
Okay. Number 5 on my docket, Cassandra Dow.
I mean, she definitely smokes, what, 2 packs a day at least? Would you say 2? 2. 2 packs a day.
Davenport, Gregory Reeves, 233-000-3408. We have Ms. Height on this matter. What?
I'll say this. This county, okay, so guardian ad litems, which are what the people that are doing this job are generally attorneys, guardian ad litem, but in this case they are not. This county does not have attorneys always doing it. So it bothers me. I don't like how it occurs here. I prefer when it's an attorney doing it, acting as an attorney for their client. Hi, Hayden. Hi, Jay from Michigan. Anybody else that I missed? Say hello back in the chat. Tell me what you had for dinner. Is Marlena in her closet? Ugh, I don't know. Am I in my closet? It's the way we live.
Let's see, do we have Mr. Reeves?
Right.
Okay, and who is Marlena that's turned on their camera?
I am Adeline's maternal aunt. Back in May of 2022, I started the emergency guardianship. And then May of this year, since Greg was doing everything he needed to do and was doing what he needed to do, I decided that to have her transition back to him. But I'm only here because Adeline, even before all this, since she was a month old, she's been staying with me weekly since she was a month old.
I'm gonna have you pause there for a minute. I'm gonna hear from the parties first, but I thank you for letting me know who you are and why you're here, and we'll come to you shortly, okay? Now, do we have Mr. Reeves present? Are you on the Samsung?
Yeah, he's trying to figure out his thing.
I just sent a request for you to unmute.
When court started, he was having some issues. It was showing just a screen that said the host will let you in soon.
Yeah, he probably was in the wrong courtroom. People log into the wrong docket that has not been started. Because if they log into this link, it puts them into our waiting room and notifies me. Okay, so Mr. Reeves, can you send a message and let us know if you're still trying to unmute? I've sent you requests to unmute. Well, then so he's responding to me saying it keeps telling him the host is not letting you unmute. And I'm just telling you, I'm sending you requests as the host, asking you to unmute. I haven't blocked your ability to unmute. So you'll need to log out and log back in. We'll come back to your case. I'm going to call one case in while we wait for him to get reconnected. I'm going to go back to number 2 on my docket. It's 213-0054208. Desiree Camba and Ruben Camba. Do I have you both with me?
Yes.
Okay.
Yes, Your Honor.
Okay. Let me jump into that file.
We had a Zoom fail. We had a drug test.
We have new contempt motions scheduled for December 6th that Mr. Camba has filed. But what we're here on today is Desiree Camba's motion for contempt dated November 1, stating that Ruben broke the no contact order by sending mail to my house. Ms. Camba, is that what you're wanting to proceed on today?
Well, there was 2 in there. There was that one that he sent mail to my house, and then that he broke the no contact order on September 30th at the YMCA.
Okay. Have you served him those documents?
Yeah, they were all together.
She has not served me, Your Honor.
Well,
I served him. The police did.
Okay, I don't see an affidavit of service of that motion. So when we were here on November 1st, we kind of had the same issue. But at that time it was Mr. Kamba who had not served you. And so you were not here, Ms. Kamba, because you had not been served. So I struck the matter and asked him to renote it and file proof of service. Then on that same day, November 1, you filed a declaration and an order to show cause for today, but I have no proof of service and I don't have any reason to believe that he's received it because I don't see a response. So again,
Your Honor, I did go into the courtroom and found that we had court today, and I
right.
paid to get the paperwork and everything, and I did file a response yesterday.
And she hasn't received that response, I assume.
No, and I paid the police to do my work.
Okay. Well, I'm just telling you, I don't have the proof of service, and he does
I'm sorry,
have
ma'am,
to be
what?
personally served with this.
I paid the police to do my work? Is that what she said? Does she mean she paid the sheriff to serve him the documents? I think that's what she means. But what she's saying sounds a little more nefarious than that, doesn't it?
Right. I don't have any proof of that. So I am going to strike today's contempt hearing as well. You will have to renote it when you can provide proof of service to the court.
So I have a question real quick. Do you know how long it takes for the sheriff to give you back your papers?
It shouldn't take long, so I don't know. I would have no way to know that, except it should not be very long.
Okay, because I mean, I gave it to them like literally after I got your signature or whoever's signature, and I called them and they gave me 2 different responses. So I didn't know honestly if he received it or not, because I went there and they couldn't find my case. And then I called them later that day and they were like, oh, well, we're out doing it now. And I was like, okay. So I didn't know what was going on with it.
Okay. Well, and I'll just, so yes, I can't move forward on your motion today until I know that he's been personally served and have that in the file, proof in the file. Similarly, you all are set for December 6th right now on Mr. Kamba's motion for contempt against you. But similarly, I don't have proof of service of that motion. So I'm just giving the party a heads up that we're kind of in a position where you all are on my dockets almost weekly or every other week, but there's rarely, if ever, proof of service. So in every instance, I really encourage you to have that filed. Reach out to the sheriff's office, get the proof of service, file it with the clerk. You can help facilitate that if they have not filed it with us, okay?
Okay.
Mr. Kamba, anything else that you need the court to know today?
No, I haven't seen my son in over 2 months, and I'd like to see him effective immediately.
Okay, well, today I'm here on a motion for contempt. I'm not here on a motion to change visitation.
Well, no, so she took it upon herself to say that I was in contempt and just for existing in the same area when she showed up, and I left. So, I mean, this was already addressed to the court once. And I'm sure you remember that it was dissolved. And then now she's trying to bring it up again. And then on top of that, she's claiming that I served her paperwork.
And sir, all I can decide on are motions brought in front of me. There's nothing in front of me on this issue. Please file that, serve it on her, and make that request of the court. Okay.
She's avoiding being served, Your Honor, and you're well aware of this.
And then I'm not well aware of this. What I can tell you, Mr. Kamba, is that you can file proof of 2 attempts at personal service, and then we can talk about alternative service, such as mail, email, social media, text messages, etc. But you have not filed proof of any attempts at personal service.
Okay, and then my response that was filed today or yesterday, sorry, that has to be served to her as well.
It does. Anything that we don't do trial by surprise in Washington. Anything that you are filing with the clerk needs to also be served on the other party, always, in every case.
Okay.
Okay. All right. Well, we have you all back on December 6th, Mr. Kamba, on your motion for contempt. But again, right now, I don't have that proof of service. So just giving the party a heads up on that.
Yeah.
Okay.
Is there a way that we could set a time for that? We can do an exchange of papers, not myself personally, but I have somebody, a server, and so she could stop avoiding being served.
I cannot coordinate proof of service. So you will have to work on that with Ms. Kamba or with the sheriff's office or with a process server.
Okay.
All right. Thank you both.
And also, in response to the contempt, like I said, I did file it yesterday.
I'm not hearing. I'm not going to hear any argument on the contempt because sir, Mr. Kamba hasn't been served on you.
No.
Your response hasn't been served on her, and you haven't served your contempt on her. So I am going to end the hearing today. You all are scheduled to be back on December 6th. Please make sure I have proof of service.
Okay.
Thank you both.
Thank you.
All right, let's go back to number.
Judge, be strict on these guys. Sorry, I'm eating a taco, by the way. A burrito. Would it be burrito because it's soft shell? It's taco seasoning. I'll say that. If you're just getting here, go ahead and like the video. It's a Friday night. It's after Thanksgiving. I would appreciate it. I'm Canadian. It wasn't my Thanksgiving, but I really appreciate it. Go ahead and like the video. Subscribe to the channel. Make me a happy girl. Also, this is it fits perfectly in my hand. It's like a perfect size, if you know what I mean. Go ahead and tell me what you had for dinner. I'm gonna guess that most of you did not have tacos for dinner, that you had something turkey related. Was it turkey related? Tell me all about it. I want to hear about it. And if you wish you had something different for dinner, tell me all about that. Love it.
5 and see if we have Mr. Reeves with us.
Yeah, can you hear me now?
Yes, we can.
Okay, perfect.
Thank you for trying that again. This is 233-0003408. Let me just get back into that file. Just a minute. So when we were last here on October 25th together, we appointed Ms. Height, and I think this was just set on for kind of an initial review, essentially to make sure folks have been in contact with Ms. Height. So Ms. Height, let me just start with you. I know you were recently appointed, so I'm not expecting the world here, but just maybe a touch base on how things are getting started and if there's any guidance the court needs to be involved in.
Thank you, Your Honor. Started is probably too optimistic a word. I was appointed on the 1st. I sent out packets on the 2nd of November. And subsequent to that, I found out from Ms. Davenport that I had been given an incorrect address. I resent her packet on the 14th of this month. I have not received anything back, which is not surprising given that short time frame. Mr. Reeves' packet, which went out on the 1st, I've heard nothing back from. So I essentially have no information. My understanding from reading part of the file was that Mr. Reeves did not believe a GAL was necessary at this time. So I don't know if that's something that he was hoping to address today. That is literally the extent of my information today.
Okay. So I'm just looking to see, I think Mr. Reeves, since the last hearing, you had filed a request for reconsideration that kind of was in the form of a letter. So I'm not sure it really got logged in as such. So it sounds like you are stating you all have an agreement and you don't need a GAL. Is that what you are telling the court, sir? And then I'll come to you, Ms. Davenport.
Yeah, so basically, I felt like there was just kind of some confusion. It might not have been listed under this case, but we had a GAL within less than a year. It was Mallory Smith, and I did submit the report. And I kind of just felt like this last case, we were ready to go to the 50-50, and then it came up about Marlene and her sister, and then that's when the whole GAL thing. I don't have problems with her sister and don't necessarily agree, but if it means the court can come to an end, then I have went into compliance with that. I mean, like I said, I don't think that Marlene is a bad person or anything, and I don't think it's bad there, but if it means court coming to an end because it's hurting my work, me financially, and all this stuff, I just want the 50-50. And then I kind of told Cassandra and her sister that they need to duke it out their problems. If there's like I know there's like grandfather or grandparents' rights. I don't know if there's like aunt rights or anything, but I don't feel like I should continue this court battle because of what they have against each other. I would just really like it to come to an end. I know that me and Cassandra have agreed on the 100%, maybe not necessarily the whole how she feels about her sister, but I really don't want to be a part of this and keep going to court. Like, my work's getting kind of upset with me. It's been going on for almost 2 years, and I just wanted to come to a close.
Ms. Davenport, what do you want the court to know?
Hi, that I am in compliance with the 50-50. I think Adeline is safe with Greg and I both. And there's no reason why she can't have equal time with both of her parents. And then with the whole Marlena thing, just a second. Sorry. I have to pause this. I'm sorry.
Ma'am, your audio is worse than mine. And I mean, seriously, like, people complain about my audio all the time. Also, if you're just getting here, go ahead and like the video. Subscribe. It's Friday night. It's okay. Do something you normally wouldn't.
Care went out of town for Thanksgiving, so.
Oh, totally understood.
Sorry. Yes, baby. Okay, I'll fix it. You're being very patient. Thank you. Which one? That one? Okay. I'm almost done, honey. Thank you. Okay, I'm so sorry. Anyway, I know that Marlena is attached to Adeline, but I do have concerns. Like the doing dabs in front of my daughter. When she was going around Marlena and staying the night, I don't believe my sister's done anything like that to my daughter. But
okay, so that's that's not what we're here for. So we're here for the first GAL review.
Oh yeah,
I'm hearing. Hold on, I'm hearing you and Mr. Reese telling me you don't want a GAL. I'm not reversing that decision. I am keeping Ms. Height on this case. I do feel like this court has to make a ruling on what's in the best interest of the child. And because I know that at some point a guardianship was filed for this child, I am not just going to take at face value from Ms. Davenport and Mr. Reeves what is in the best interest of the child. We do need someone else to meet with the parties.
Another reason, ladies and gentlemen, if you can, avoid going to court with your personal family issues, because this judge has just said, oh, the mom and the dad agree on something, but a previous judge said that they should have a guardian. Let's have a guardian. There's fucking $3,000 down the drain for them. Seriously, that's how much it costs to have a guardian in this, at the minimum. At the minimum, it's going to be $3,000. Mikey, you asked in your poll today, I don't know if you're listening. Maybe he's just gambling. I don't know. But you asked about leftovers. Are you eating leftovers? That's a good question.
To investigate this and to report back to the court. So that will include all parties involved. I am keeping Ms. Height on the case. We will, I think we set review dates otherwise. And what I would say is Mr. Reeves and Ms. Davenport, please, you've received paperwork. You probably will also get requests to talk with Ms. Height. Those are court mandated obligations that you have. So I do need both of you to participate in that.
Okay.
I think our interim report review date is January 10th, 2024 at 9 a.m. So that will, oh, go ahead.
Evidently, I wasn't listening. He ate Chinese every day or all day and didn't bring any leftovers home from his daughters. Okay, well, I get that. I mean, I don't know. I like Chinese food too. I make really good Chinese food, which is weird. But you like chow mein and wonton soup and chicken fried rice and pan fried prawns? I'm your girl.
I'm sorry, Your Honor. I was wondering if the January 10th date could be moved to either the 3rd or the 17th of January.
Absolutely.
I am unavailable on the 10th. I'm available both of those other dates. And then the final review, as you see there, is for mid-February. I'm hoping that could still stand.
Okay.
The mid-February date. I don't necessarily want to change that one.
Okay. Let's do January 17. We'll strike January 10th and we'll change it to January 17th at 9 a.m. for the interim review. And then we'll keep the February date, but certainly we can revisit that on this January 17th if we need to, depending on how the investigation goes at that point.
What was the February date?
That.
Ms. Height, go ahead.
I just said thank you. I appreciate that change.
Okay, thank you. And then I think Mr. Reeves, you were asking a question. Go ahead.
Yeah. What was the February date again? It was like the 13th or the?
Yeah, February 14.
14th.
Valentine's Day. Oh my God. Can you believe people are already planning for Valentine's Day? Like the judge, she's like, oh my God, sir, get your Valentines in order because February 14th, you're in court. You ain't gonna have time to court anybody else.
And then I had, so I have been waiting for a phone call. I didn't know it was going to come in the form of mail. I will recheck through my mail. Is it like a big packet or is it like just a regular letter?
It's a packet that looks like this.
Okay, I will re-look through my mail and then if I cannot find it in there, then I will reach out to you.
Okay.
All right. Sorry about that.
Okay. Anything else we need to do today?
Can I speak now or were you waiting?
So I don't know that I need your input today unless there was something real urgent and pressing. What?
Well, Adeline has been, even after my guardianship went to Greg, she's been staying with me one night a week. And Greg, which I can provide proof of this, but Greg and his mother both told me that Cassandra was harassing Greg really bad to the point because of Adeline staying the night with me. But she's been doing that since she was a month old. And her and I are extremely close. We have a very strong bond. And so now I am told that she can't stay one night. I was informed, this is how it was told to me, that if Adeline continues to stay one night a week with me, that they would reopen a case and that Greg couldn't do that because of work and he just needed it to be closed, which confused me. And I was going to submit a statement, but I figured
yeah. So ma'am, you're not a party to the family law matter. So if there's information that you have regarding what's in the best interest of the child, please reach out to Ms. Height. That will be the avenue for that. I can't actually take testimony from a non-party right now, just orally.
Okay.
So, because I understand I understand there's no guardianship in place right now today, correct?
Yeah. No.
Right.
Because
So,
Greg stepped up and did what he needed to do, me and the guardian ad litem at the time.
understood. And that's why you wouldn't be a party to this family law case, even though you were a party to the guardianship case. That case has ended. But your input is valuable to Ms. Height. Please reach out to her. And then that information can come when we meet back on January 17th. But it is true, without a guardianship in place, you don't have legal standing over the child sitting here today. So you yourself can't mandate, you know, visitation. If a parent chooses something different, that's certainly their prerogative at this time. My last notes show Ms. Davenport and Mr. Reeves stating that 50-50 was going well informally. And right now that's what's in place.
Yeah, and no, I'm not here for any visitation. I just wanted to kind of figure out what was actually going on in the case because
okay, and again, I'm gonna go ahead and end the hearing on this matter again because you're not a party. I can't give you legal advice. I mean, you're welcome to participate. I mean, you're not participate. You're welcome to watch these proceedings. But since you're not a party, there's really no kind of request you can make of the court in this case. But again, reach out to Ms. Hyde if you want to give some input.
Okay, yeah. I have, yeah, okay.
Ms. Hyde, go ahead.
Thank you. Your Honor, my general system is that once I've received my intake packets and reviewed those, I set up visits with the child and the parents, and I do not typically contact collaterals until after that time. So it would be some time before I would have any information from Ms. Marlena. And with that in mind, I wonder if you could encourage the parties to return their packets as soon as possible. That would certainly help me move this forward.
Yes. I think that's completely realistic. And I think we did discuss that. Mr. Reeves and Ms. Davenport, go ahead and make sure you return those packets as soon as possible. I think we've done all we need to do today. I'm going to go ahead and end this hearing. Okay.
Thank you. Thank you, Your Honor.
Thank you.
Thank you.
All right. That leaves me with numbers 6, 7, and 8 on my docket. This is Annette Jacken and Eliezer Jackson. If you two want to go ahead and unmute. Are you two able to unmute and turn on your cameras?
Can you hear me now?
Yes, I can.
Thank you, Your Honor.
I am here.
Okay. Okay, we're here essentially, according to my notes, on 3 matters, all under the same docket, 233-0024-408. Most predominantly, and the rest of the other motions kind of flow from it, is Mr. Jackson's motion to vacate a prior judgment. When we were here last, we continued this case to today because Mr. Jackson was seeking counsel, or new counsel, I should say.
I was muted. I like fish too, and I want to go fishing. Jay from Michigan, are you going to take me on a fishing trip? I want to go fishing. Next year, 2024 goals, I want to go fishing. There we go. We're laying it out. Lay out your goals for 2024. I know, now the audio's back. I'm not used to having my microphone back. You can almost see it. I don't want to lift it up because it'll fuck it up, but I do have it back. I'm saying one of my goals for 2024 is to go fishing and catch some fish because I want to go fishing. I like fishing. I'm actually pretty good.
Mr. Jackson, can you let the court know, and I don't have cameras turned on for either one of you, can you let the court know where you're at? I don't see notice of representation at this time.
I have not gotten any counsel. Everybody I've talked to will not work in Cowlitz County. So I'm still seeking counsel.
Do you have any appointments set up or?
No, ma'am. Like I said, everybody I've talked to will not work in Cowlitz County.
Okay. So what is your request of the court today?
Continue. You know.
You're asking for another continuance? Is that correct?
Yes,
or are you asking to proceed on your motion to vacate today?
Let's proceed with the motion to vacate.
Okay. Ms. Jackson, are you ready to proceed on the motion to vacate?
Yes, I am, Your Honor.
Miss Jackson, ooh, I am for real. I want to go fishing next year in any lakes or oceans. Seriously, I'm in. I am fucking in. And I'm fun.
Okay. So that is the first issue we're going to take up. I do note that there was the initial motion filed. There was an October 18, 2023 response filed by Annette Jackson to the motion to vacate. And then
Nancy, I think you're the only person asking for me to sing. Also, Jody, are you looking for my attention? Is it me? Is it me you're looking for? You want me to sing it to Mayor? Chris is leaving. He's like, oh, peace out. Peace out, A-Town. Is there great? Oh, I've heard of Lake Havasu. We might get a little dirty. Oh, I've heard that fishing is a little dirty. Actually, I've been multiple times and I got a little dirty. Let's put it that way. Thank you, Christopher Engelby. Appreciate you being here with us. What were you talking about? You want to? Okay, let me prep my voice and then I will sing to Mayor and Sashina for their birthdays.
I've also received an October 31st declaration from Tanya Quinada. I have received an October 31 declaration from a Christopher Pangelinin, if I'm pronouncing that correctly. I've received and reviewed the October 20th declaration of Mr. Jackson that does also relate to his motion to vacate, as well as response to some of the potential contempt motion that Ms. Jackson has filed. What I don't see is whether that November 20th declaration of Mr. Jackson was filed on Ms. Jackson.
Yes, it was, Your Honor.
So I received in the middle of the night 2 emails. One was at 11:43 p.m. on Monday night, which was the 20th, and one was exactly at midnight on the 21st, so yesterday. I have truly, honestly, no clue which one I'm going by, because the declaration, the writing part is the same, just not the evidence.
I'm sorry, I didn't quite understand the last part you said.
The writing is the same of both of those, and just not the evidence. It's 2 different things that I have, the exhibits. So I'm not sure which one he would like to go by, especially beside, it got served me in the middle of the night. So it was, yesterday morning.
Yeah, so I guess that's my question. This case has drug on for quite some time.
Yes.
My issue, though, is that Mr. Jackson appears to be filing some additional evidence regarding, I mean, I think we can still move forward on the motion to vacate because I think all of that evidence has been properly served and everyone's had a chance to respond. But it looks like he's making some arguments with regard to your motions for contempt that I'm guessing you want to respond to.
Well, I would like to know which ones he wants to vacate now.
Yeah, so that's not my question. My
Oh,
question
okay.
is whether so you have very recently received this paperwork, which really isn't timely. All documents need to be filed on other parties with sufficient time to respond to a hearing, and typically that's at least 5 days before the hearing. These were filed 2 days ago with the court. You received them, it sounds like, last night. Are you planning to respond to the documents that he has filed on you?
What, you mean by writing or just by now at the hearing?
Either one.
I mean, I can respond to it right now as I'm talking, you know.
Have you had enough time to review his November 20th declaration?
Yes, I did.
Okay. I mean, typically, I would say filing something on someone by email, which also is not sufficient, at midnight is not sufficient. So, Ms. Jackson, if you wanted time to respond and prepare for a hearing on it, you certainly can. It sounds like you want to move forward today. Is that correct?
Well, so, Your Honor, we have been doing this for months now,
Yes,
and they
understood.
will always do stuff in the last minute to drag it out. The whole, you know, when I say they know who they are. And it's just like I get this declaration of Christopher Penglin and of Tanya, and this never got served to me. So, you know, I saw it and I had to drive up to Longview, pull it, you know. It's like they are doing certain things. So that's frivolent. What they are doing to me is doing everything last minute. So we are pushing this out and out and out. We all know he's not going to get an attorney again. This is, you know, because I mean, his other attorney had filed when he quit with an RCA 16A and B,
So,
which
yep, hold on, Ms. Jackson. I'm just limited question here. Are
Yeah.
you asking for more time given the untimely and improper service made on you, or are
No.
you asking to just move forward and you're ready to respond?
I'm moving forward. I'm over it.
Okay. All right, Mr. Jackson, we're first going to go to your motion to vacate. As I understand it in looking at your motion, at the time temporary family law orders were issued in this case, you were represented by an attorney of your choosing. And what you are arguing at this time is that this court should vacate the temporary law orders. You've argued ineffective assistance of counsel, breach of professional ethics, and other duties, primarily, well, all related to what you believe to be actions or non-action by your prior attorney. Is that correct?
That is correct.
Okay, so I'm going to turn it over to you for argument on why you believe this court can and should vacate those temporary orders. Go ahead.
I had no knowledge of two of the cases that went to court. I found out that there was 4 times they went to court. I had no knowledge, and I was not represented, and I was not there.
Okay, well, I have a couple questions about that because every time that we listen to court, what do we hear? What do we hear? Because I'm lazy and I do not cut the boring parts out of court. We hear them ask about service. We say, like, literally, this judge 20 minutes ago complained to somebody because every 2 weeks they're in their court not achieving service. Service is a real thing legally in the legal world, and I find it hard to believe that they would have had service achieved to the point where a judge would approve it, but not actually received it. Okay, you want singing? I will sing one time. I apologize in advance to everybody who's hearing me singing because most people do not like to hear me sing. Let me not start a fire with this, please. Thank you. Okay. Happy birthday to you. Happy birthday to you. Happy birthday, dear Sashina and Mayor. Happy birthday to you. Woo! There.
Not sure if the attorney knew about it because he wasn't there either. So I didn't get served any paperwork saying I had court or anything. So that's where I'm standing.
Okay. Ms. Jackson, briefly, I'm going to hear from you just on the motion to vacate. I don't want you to get into the contempt or discovery issues right now.
Yeah.
Go ahead.
He got served each time his attorney got served. He got served. I even reached out by
Hi, Paul. Do you believe that she got served? I don't believe she got served. You guys are so sweet. You literally make me delusional that I can sing for like a short while after these lives. I'm like, you know, that there were 28 people or 29 people that were like, she sang. And I said, hi, Paul. You like my boobs, Paul?
message, letting him be aware that, hey, there's a hearing. I also asked him at one point, does your attorney still works for you? And he's like, why? So I explained to him why. And I mean, truly, honestly, I have to say, if I have an attorney, I'll reach out on a regular basis and to see where are we standing. And if the attorney doesn't respond, maybe I should get a little bit more aggressive. I don't know. And the most,
Ma'am, I need to go back now because I've been touching my boobs and talking about my boobs and you're going aggressive. So we got to go back now. Paul said he's actually into my boobs, which I like. Hold on, let's go back 20 seconds. I'll go back 20 seconds too and I'll pull my boobs out even more. Oh, it'll be great for everybody. Get more aggressive.
so I explained to him why. And I mean, truly, honestly, I have to say, if I have an attorney, I'll reach out on a regular basis and to see where are we standing. And if the attorney doesn't respond, maybe I should get a little bit more aggressive. I don't know. And the motions that he's trying to vacate, they're overridden.
Thank you, Nancy. Perfect timing, honestly. Just reinforcing my aggressive nature. We love you, Nancy. Thank you for being here. Thank you for being part of our family. This is a great family. I love you all. Seriously. You're keeping me going on a Friday night. We're going late tonight. I'm just pre-warning y'all. It's Friday and I don't want to stop.
Already. They don't even exist no more from July and August because Judge Evans wrote a new order for September 12th. So there's my 2 cents.
All right. So what I'm going to do is kind of go through a history of this case from early on. This petition for dissolution was filed on June 7, 2023. Ms. Jackson filed a notice of appearance pro se on June 7, 2023. Mr. Jackson had an attorney notice of appearance filed on June 26, 2023 by an Ivan Culbertson, private retained attorney on behalf of Mr. Jackson. A response to the petition for dissolution was filed that same day. Motions for temporary family law orders were actually filed by Mr. Culbertson on behalf of Mr. Jackson. Financial declarations were provided that same day. It was noted for motion docket on July 18, 2023 by Attorney Culbertson. on July 12th, you all were seen on this unrepresented docket. Mr. Culbertson appeared. Because Mr. Culbertson was representing the parties, the case was moved to the represented docket.
We don't watch the represented docket because it's sort of boring. Like, lawyers know what they're doing. We're more into like people that don't know what they're doing, to be honest. It makes for more fun court. I don't know how else to explain it. I mean, think about it. Have lawyers that have been trained for years of their lives to be in front of judges, or have a fucking loser who looked up a few things on the internet, thinks he knows how to boss the judge. You know which is better. Also, hi, Bruce. Hope you're doing well. Make sure you've dropped a like. I'm about to go check on the likes, and I'm going to be disappointed if we're low on likes. I'm just telling you guys right now. It's Friday night. Likes are like shots. Shots.
Then on July 18, 2023, in front of a judicial officer warning, the case was heard. Ms. Jackson was present. Mr. Culbertson, the attorney, was present. Argument was taken regarding the temporary orders. The court made rulings regarding the temporary orders on that date with Mr. Culbertson present. Those orders were signed on July 8, 2023 by the judicial officer.
T-Rex was here earlier. He sent me, did he send me? Yeah, he sent me a super chat, and he joined as a member. Ladies and gentlemen, you too can join as a member. But not only that, can you also make sure that you turn on gifts on your account? Even if you're not a member, you don't want to pay any money. You say, no, Paisley, no, I will not pay you any money. That's okay. But turn on memberships, because there are fucking cool people here who prefer to gift memberships rather than super chat, and that's okay. We love it too. YouTube Daddy takes the same, but at least this way somebody else gets a little bit of the game. That's what I say. Loud Elvis is here. How were the pistachios this evening, Loud Elvis? Tell me all about it. Humble brag us. Please. Oh, my name has been doxxed on the internet, so may as well own it. Anyways, let's keep watching.
So now kind of what's happened since is Ms. Jackson has asserted that Mr. Jackson has not adhered to the temporary orders, and she filed contempt and show cause matters with proof of mailing to Mr. Culbertson. I'm just looking for his intent to withdraw. So then through this process, on September 12th, well, let me back up.
Thank you, Amanda. I appreciate that. You're so sweet.
I'm going back to a September 5, 2023. This is a motion that Ms. Jackson filed for contempt with an affidavit of service on Mr. Jackson. A motion hearing was had in front of Judge Evans on September 12, 2023. At that time, Judge Evans took testimony from Ms. Jackson regarding service. The court responded that at the last hearing, they had discussed service issues and Mr. Jackson had been personally served. Ms. Jackson had also served Mr. Jackson via email and mail because of a lack of response from Mr. Culbertson since the time of the temporary orders. The court reviewed the Washington State Bar Association website to verify the address for Mr. Culbertson. The address of service did match. Mr. Jackson was present, or excuse me, Ms. Jackson was present and indicated she had not received any response or correspondence from Mr. Culbertson. The court then issued a ruling that granted Ms. Jackson's request to increase spousal support, provide housing assistance, and other orders within the September 12th motion hearing. At that time, Judge Evans did find that service was acceptable. There also, at that time, well, strike that. Let me back up. On September 25th, 2023, this court received Mr. Culbertson's notice of intent to withdraw. Then we end up here because Ms. Jackson has continued to assert that Mr. Jackson has not complied with the temporary orders. And Mr. Jackson now has raised the ineffective assistance of counsel arguments to the court. My finding is that motions to vacate are appropriate where, for instance, there is an irregularity in the proceedings or some other fault can be found in the process, how these orders happened. That is not the case here. This is a case where Mr. Jackson's remedy lies with any action he has with his attorney. This was a private retained attorney. His ineffective assistance of counsel, and I'm not making that finding, but I'm stating the argument that there was ineffective assistance of counsel is not a grounds for this court to vacate a properly ordered temporary family law order. Similarly, the other grounds regarding any breach of ethics by Attorney Culbertson similarly are not grounds to vacate. A client will be held to the orders that their attorney was properly notified about, was present for, or had the opportunity to be present for. So I am at this time denying the motion to vacate.
Thank you, Your Honor.
So let's talk about the other two motions we have in front of us. One is a motion hearing to restrict abusive litigation. And I believe, Ms. Jackson, that's what you have filed.
Yeah.
Okay. And then a motion hearing regarding contempt issues. Here's this, I'm gonna short circuit this a little bit. Just based on the pleadings, I don't find that there's enough for me to make any sort of ruling regarding abusive litigation. I have denied Mr. Jackson's motion to vacate the prior judgments, so I think it's appropriate to move forward on the contempt issues. But hold on a second, but I am not finding, as far as Ms. Jackson's motion to restrict abusive litigation, that there's any merit. Mr. Jackson, go ahead.
I was the one that filed for abusive litigation as well.
Oh, yeah.
Well, I think there's two, well, it's showing up as one, but you both have made that request in your motions. So
I never received anything from her.
Well, I was just looking at it. It's in a document. Yours was filed on October 11th. And then her request is, just a minute, I will get there. On October 18th, 2023. Unless I have mistaken, did Ms. Jackson, did you not intend to file your own motion to restrict abusive litigation?
You know what, Your Honor, I really don't know at this point because there's so many paperworks that I truly honestly, I do not know anymore. I was trying to move with my daughter in. It's been like, paperwork. So I truly honestly do not know at this point if I filed for it. Probably because I mean all the stuff that they're saying that I have overdone on paperwork, which I just think I just filed everything as supposed to.
Okay. So I guess let's make the record clear then. I took your October 18th, 2023 request to be a motion to restrict abusive litigation. Sounds like you're not making that motion to the court, so we can strike that.
Yeah, let's just strike it. I'm just like,
Okay. And then let's go back to Mr. Jackson's motion to restrict abusive litigation. I do have that motion in front of me. My understanding.
Before she talks about the motion of her ocean, seriously, ladies and gentlemen, thank you for being here. Will you tell me if my audio is clear? I've been working on something new tonight, and I hope that it's working. It's a little quicker on the uptake. Seriously, Mayor, happy birthday. Sashina, happy birthday. I know there was somebody else, Alex McAttack. I believe Alex McAttack comes to the channel too, once in a while anyways. Thank you and happy birthday to her. Let me tell you something. Recently I was on Colin's channel. Colin, definitely not Cromwell. And I will tell you something. My audio is quicker than my video. Oh, perfect. We're superseding the video now. A little hollow slightly. Well, Amanda, did you tune in the last couple nights? Because I feel like tonight it might be good. But anyways, I was on Colin's show the other day, you know, as I am, as me. And I think everybody that hangs out here and chats here understands that I am who I am. This is not an act. Maybe some people believe it's an act, but this is not an act. This is who I am day in, day out. If I could turn it off, I might. I'm not kidding. I fucking might. But I can't. So this is who I am. And recently, like I said, on Colin's channel, I got called a Karen. Which, first of all, we know on this channel, I am not a Karen. I would never use my privilege to be a Karen. I am a NERAK, reverse Karen, NERAK. That is a reverse Karen. That means that I use my privilege for good to try and help people as opposed to because I can. I just laugh though, and I just wanted actually the reason I say this is because I want to thank each and every one of you for being so lovely and thankful and kind. I haven't had to deal with negative comments in a while. I know that's what happens as we get bigger, but to be honest, I really enjoy just hanging out with y'all and us all being nice. I just like it. I fucking like it. I don't know what to explain. Anyways. Yeah, could you imagine somebody calling me a Karen? Are you joking? Like, is that what I fucking come across? Craziness. Anyways, let's keep going.
When I read that motion is essentially kind of the basis appears to be the multiple contempt motions.
Yeah. That is correct.
Okay, so Mr. Jackson, I'll hear briefly on that matter if you want to add anything to the record.
I want to add something about the earlier judgment is I was not the September 12th hearing. I knew nothing about, had no paperwork on it. and you
But you
said I
were,
was served.
I'm not going to revisit my ruling on that. You were on September 12th, you were represented still by Mr. Culbertson. He should have appeared on your behalf. So I'm not revisiting my decision on the motion to vacate. I'm hearing now your motion to restrict abusive litigation.
Okay, well, it's contempt after contempt after contempt, and most of it is just flat out lies. I've done, especially the 18th of July order. I followed the rules right there from the beginning.
Mm-hmm.
As soon as I got them, and then the 12th I knew nothing about until I was sidelined when I was in the hospital.
Mm-hmm.
So we exchanged cars. I have no idea what money I'm supposed to put in the bank because I don't have any money.
Do you have the September 12th order now?
No, I do not. I've been looking for it. I don't have it.
They got personally served to him. They got served to him by, because I had first the sheriff's office in the courthouse. I wanted to have him.
Hold on. I'm just going to address something that's happening in the Zoom chat. So for parties.
Ooh, Phil Cordeau, thank you so much. Are you in Discord? Discord is a great way to do it. Otherwise, if somebody hits !email in the chat, there should be an email that comes up and you can email it to me. I appreciate that because honestly, I've been thinking about it. I'm like, God damn it, Paisley, you have a fucking green screen here. And yet you cannot turn it off. Anyways, !email or in Discord would be the best ways. There we go. Whoa, there we go.
Non-parties to this case. I'm not taking testimony from non-parties. You're welcome to be here observing. Please do not use the chat to talk about the merits of the case. I see that that is happening for Ms. Quinata. I'm going to delete those messages. They are not part of the court record. Ms. Quinata is not a party to this case. She has filed a declaration and that will be considered by the court. But the statements made on Zoom will not be considered by the court. Please refrain from doing so. Okay, go ahead, Ms. Jackson.
Wasn't it? No, he was talking. Wasn't he talking? I'm sorry.
Oh, Mr. Jackson, go ahead.
Yeah.
I apologize.
No, that's fine.
No, I was just saying, I don't have any of those from the 12th of September or whatever it was. I don't have those papers. I've been looking for them. And I'm not sure what it even looked like.
So Ms. Quinata keeps replying to me regarding this case. Please refrain from doing so. Otherwise, I will remove you from the Zoom hearing room. Please do not use the Zoom chat while we're in the middle of a hearing. Okay, Mr.
It's like that girl that's messaging your boyfriend and you're like, hey, bitch, could you fucking not while we are trying to figure out if we're together or not? Just joking. I don't know. Honestly, I've never been in an official Zoom. I've been in, actually, that's a lie. I've been in Teams meeting and Zoom's meetings, Teams and Zoom meetings. But Amanda, do you not think if I could show them I would? I fucking would. I fucking would.
Jackson, please go ahead. I apologize for having to interrupt you again.
So I have none of those. Again, I was sidelined when I was in the hospital about this order that I'm supposed to be following, and then I was in contempt of. I still do not fully know what it entails.
Okay. So you still don't have the September 12th order?
No, I've looked through every paper I've got.
Okay.
Which I have a lot, which doesn't even, I don't know.
Okay. Are you able to come to the Cowlitz County Superior Courthouse and get a copy of that order?
Yes, I will.
Okay. Here's what I'm going to do. On the
Yep.
motion to, hold on, Ms. Jackson, is
Yeah.
that you?
Yes.
Okay, go ahead.
So I had when on the 12th, when the orders got down by Judge Evans, I went down to the sheriff's department, filed there for it to get it served to him directly, paid my dues, everything. After 2 weeks, they still have not been filed with him. They had not been served with him. So I withdrew those, and I had somebody serving him that Saturday, which was, I think, if we look in the paper, was on 9/28.
Okay.
At 8:30 in the morning, he was served, and he opened the door, and he got by Andrew, and yeah, Brad Seansbury. I do not know his name right now, but yeah, he got served, and he was getting the papers, and everything is filed in the records that he got them.
So here's going to be my ruling. First, on the motion to restrict abusive litigation filed by Mr. Jackson, I am going to deny that motion. I don't find that the contempt motions are abusive litigation. But on those contempt motions, I do not believe under the circumstances that I can find that his failure to comply was willful, which would be required for me to find contempt. So I am denying Ms. Jackson's motion for contempt against Mr. Jackson. What I am going to do in this case, because I do understand that Mr. Jackson, number one, believes that his attorney was not giving him documents, and I don't think that's a reason to vacate, but I do think that's a reason to find that his actions in failing to comply were not willful. So I am going to request that Mr. Jackson come to the Cowlitz County Courthouse and ask for a copy, receive a copy of the September 12th, 2023 order. I am going to ask Mr. Jackson, well, not ask, I'm going to let Mr. Jackson know that because I am not vacating those judgments, you will be expected to comply with them moving forward. So please, I understand tomorrow's a holiday. Friday, the courthouse is closed. So please, by next Friday, so sometime next week, come and get a copy of that order. Make sure you understand it and you're in full compliance of it, because if Ms. Jackson were to bring a contempt motion down the road, I wouldn't necessarily be able to find the same finding that I'm making today. So I'm giving you time to receive, review, and comply with the September 12th, 2023 order before I would deem any non-compliance willful. Mr. Jackson, do you understand my ruling?
I understand.
Okay. Do you believe that you could get to the courthouse and receive that order by the end of next week?
Yes, I can.
Sorry. Thanks for stopping by, Snoopy. Glad to hear it. Judge is so... Do you think she sounds like me when she's tired? I don't know. That's not me. But anyways, let's go. But hi.
Okay. Ms. Jackson, do you understand my ruling today?
So yeah, so he has to pick up the paperwork. So is the ruling of Judge Evans, what's it called in English?
Both Judge Warning and Judge Evans' prior rulings
Yeah.
remain in place. They are not voided. They're not vacated. They are the law of the land in this case. All I'm doing today is saying up through today's date, I am not finding contempt on behalf of Mr. Jackson with regard to your most recent contempt motions. I am giving him time now that I've ruled on his motion to vacate. I'm giving him time to receive the order review it, and be in compliance.
So he has to, if he picks it up by next week, Friday, from there on out, he has to move out. He has to do all of this stuff that Judge Evans had written down as an order, right?
Well, I want to be careful here, Ms. Jackson. I understand that I assume that there might be a no contact order still in place.
It's still in place, Your Honor.
That would take precedent over this. So no, I think you're mischaracterizing my ruling, Ms. Jackson.
Okay.
So let me be very clear.
Okay.
You still absolutely must abide by a no contact order, and I don't want there to be any confusion about that.
Okay.
That is based on a totally separate cause of action that has nothing to do with a family law case. So a domestic violence no contact order has to be complied with. Failure to comply with that can result in criminal charges. So that is in no way my ruling.
Okay, but so I'm a little bit.
Hold on.
Yeah.
So I'm not gonna dive deeper into the back and forth on whether you think that the no contact order is valid or not. So let me just ask very, very succinctly, do you have any questions about my rulings today that you need clarified? Not about legal advice about the house or anything like that.
Yeah, I mean, I do not understand the no contact order. I don't have contact to him. And
again, I'm not discussing the no contact order. I'm asking if you have questions about my rulings today, which deny the motion to vacate, deny the restrict abusive litigation motion, and deny the contempt issues. Do you have questions about those matters?
Yeah, but it's right now it's like English is my second language. So some of that stuff sometimes just is like really hard on me to understand any of that. So I don't know what to tell you. I'm like really confused right now.
Okay. Mr. Jackson, do you have any questions for me about my rulings today?
No, ma'am.
Okay.
Do I? Well, I do, yes.
Okay.
So after I get this order and I go over it, do I have the ability to contest this order?
So either party always, before finality of a dissolution proceeding, can make motions to modify orders for good cause. So the short answer is yes, but the long answer would be yes, but it depends on the facts that you would present to me.
Okay.
Okay.
Thank you.
Okay, I'm going to go ahead and end the hearings. Thank you both.
So are we having then setting up a next appointment right away or not?
I am not. There's no further issue in front of me. So it would be incumbent upon the parties to renote if they want to bring a new issue to this court.
So the orders that he's picking up, I mean, are they working or not? Are they going to be good or not? I'm like really confused right now. Like,
so then if
he has to follow the
Ms. Jackson,
yes.
So I can't give parties legal advice, just like Mr. Jackson. You know, I can't throw him a lifeline either. I can't throw you a lifeline. I can only make a decision based on what's in front of me. So if you are having difficulty understanding proceedings, and I get it, it is difficult to navigate legal proceedings without lawyers. Certainly reach out to legal aid clinics or a lawyer if you want further clarification. All I can do is tell you that the temporary family law orders that prior judicial officers in this case have put into place remain in effect. Mr. Jackson is bound by those absent a motion and ruling to the contrary. At this point, I am not setting a review date because there's nothing else for me to decide unless the parties bring a new motion and note it for docket. Okay?
Okay.
All right. Thank you both, and we will go ahead and end docket.
I mean, she might end docket. I'm not ending docket because it's Friday night and I don't want to. So we're gonna watch the Travis County bond docket from 12 hours ago. Give me 1 second to get that out. If you're just getting here, this is a great time. Tell me how much you like my boobs. They look great. If you don't like them, please tell me that too. I'd love to hear about that. I'm a bit of a masochist, so tell me all about it. How you hate it. Also, tell me what you wish you had, or tell me what you had for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. Let's go ahead. Let me grab this here. Seriously, I am a masochist. I'm totally fine with it. Tell me, oh my God, your tits are disgusting. I hate them. Are they your main personality point? Uh, just know I can take it. I signed up this so
and you
long
can hear
ago.
them, please.
Oh, sir,
Yes,
yes,
Your
we can hear
Honor.
you. Hold on.
Señor José Chávez, ¿me puede
No,
escuchar bien?
escuche, no, no español, escuche. No escuche español. You shut up, ma'am. Hold on. Yeah. You gave up boobs when your mother kicked you off of the tit, Philip. That's a great thing to talk about. I breastfed for 2.5 years, so did your mom kick you off before then? Was she as pretty as me? Ew, weird question. It's okay. Uh, next screen. Seriously, I actually do not want to stop because I might get in trouble when we're done. So I'm just, when you're like a kid and you're doing something and your parent can't get you in trouble until you're done, so you keep going. That's what we got going right now. We got court to watch. I can out court anybody. I hope.
Señor Leonel Castellanos Hernández, ¿me puede escuchar bien?
Sí.
Señor José García Osorio.
Sí.
Señor Eleazar Martínez Hernández.
Sí.
Yes, all of them can hear me.
Okay, great. I'm Michael Coffey. I'm the magistrate here at Central Booking today.
Yo soy Michael Coffey, soy el juez aquí en la unidad de detención del condado de Travis.
I need to go through with you the rights you have in the criminal system, the bail bond system, specifically what you have been charged with and what your bail is set at.
Mi función el día de hoy es decirle cuáles son sus derechos dentro del sistema penal, el sistema de cómo depositar fianzas, las acusaciones en su contra, la cantidad de la fianza.
If you have questions, I can try to answer them.
Si tiene usted preguntas, trataré de contestárselas.
I will go through all of this first, and then remember your questions when I speak with you individually, I can try to answer those.
Voy a decirles todo esto primero y después, y trate de recordar la pregunta que tiene para que cuando hable con usted me la haga.
You are in a criminal system, so you need to know that things you say or sign can be used against you in court.
Está usted en el sistema penal, así que debe saber y estar consciente de que lo que diga o cualquier cosa que firme podría ser utilizado en su contra.
You do not have to meet with any peace officers about the facts of your case. You do not have to meet with the state's attorney about the facts of your case.
No está obligado a reunirse ni con los elementos de la policía para hablar de los hechos de su caso, ni con los representantes de la fiscalía para hablar de su caso.
You do meet with either of those, you can have an attorney with you.
Si usted se reúne con cualquiera de ambos, tiene derecho a tener a su abogado con usted.
You can hire any attorney you want to represent you.
Usted puede contratar a cualquier abogado que usted quiera para que lo represente.
You are unable to afford an attorney, you can request that the court appoint an attorney to represent you.
Si usted no tiene dinero para contratar a un abogado particular, tiene usted el derecho a solicitar que le pongan un abogado gratuito de oficio.
you would like a court-appointed attorney, let me know when I speak with you individually, and let the pretrial service officer that will be around to interview you know that. They will have a paper for you to sign requesting that.
Si usted va a solicitar abogado gratuito de oficio, me lo debe hacer saber a mí cuando hable con usted individualmente. Además, se lo tiene que hacer saber al funcionario del Departamento de Servicios previos al juicio que va a estar entrevistando personas y él va a tener o ella va a tener formulario que usted va a tener que firmar para solicitarlo.
If you are charged with a felony, you have a right to an examining trial.
Si se le acusa con un delito grave, tiene derecho a una audiencia indagatoria.
That is a hearing in front of another judge to determine if there is probable cause to believe you committed the offense for which you have been detained.
Esa es una audiencia que se celebra ante un juez distinto en donde él ha de determinar si existen motivos fundados para continuar con su caso y para la razón de su detención.
Your attorney can help you set up an examining trial.
Su abogado puede ayudarle a programar esa audiencia indagatoria.
You are not a citizen of the United States. We can contact your embassy or consulate, let them know you've been detained, and they might be able to help you.
Si usted no es ciudadano de los Estados Unidos, podemos contactar ya sea la embajada o el consulado de su país para hacerle saber que usted se encuentra aquí detenido.
Let me know if you would like us to contact your embassy or consulate when I speak with you individually.
Hágame saber si usted desea que nos comuniquemos con la embajada de su país o con su consulado para hacerles saber que usted está aquí.
To get out of custody, you will need to post a bond to cover the amount of your bail.
Para poder salir de la cárcel, debe depositar o poner la cantidad de la fianza en su caso.
You can post a cash bond. You can hire an attorney or a bondsman to post a surety bond, or you can apply for a personal bond.
Ya sea que usted contrate a un abogado o a una compañía de fianzas para que depositen la fianza a su nombre, o puede depositar la fianza en efectivo, o bien puede solicitar que puede solicitar.
What is the temperature, Jonathan? What a great question. Let's check. I would like to thank very, very special someone who specifically bought me a space heater for keeping me warm because they know that I get very cold, especially last night. So I would like to thank that absolutely special someone who did that for me via PayPal. Thank you. That was really nice. Almost too nice. Makes me cry a little bit. The temperature right now is 40 degrees. That's cold. Holy shit. That's 40 degrees Celsius, ladies and gentlemen. And in Canadian, that's 40 degrees Fahrenheit. Sorry. 40 degrees Fahrenheit. And in Celsius, that is 5 degrees. 5 degrees. I do need an Amazon wish list. I'm working on it. Cellulite yoga pants. Working on it. Mayor and Lockeficent, which I don't say properly, are good friends. Good old friends. Anyways, let's see what else we have here. But again, thank you to the person who did that.
Y ver si le aprueban la fianza personal.
If you are released on any of these bonds, it's important that you appear back in court as you have been directed.
Si usted sale de la cárcel con cualquier tipo de fianza, es muy importante que recuerde que debe comparecer en el tribunal cada vez que se le ordene.
If you do not reappear, your bond can be forfeit and a warrant for your arrest would likely be issued. It may be much more difficult for you to get out of custody again.
Si usted no comparece a cualquiera de esas citas, se le decomisará la fianza o garantía que haya depositado se pondrá una orden de detención en su contra y será mucho más difícil que salga de la cárcel otra vez.
Does anybody have any questions about their rights or the bail bond system?
¿Alguien tiene alguna pregunta sobre los derechos o del sistema de depositar fianzas?
Who is your first person, Rosario?
My first person, Your Honor, is Jose Chavez.
Jose Chavez.
Who's Mr. Chavez?
¿Quién es el señor Chávez?
Mr. Chavez, I'm showing you're charged with a criminal trespass of a habitation.
Señor Chávez, muestro aquí que tiene una acusación de intrusión dolosa.
Mikey, thank you for being here. Was it a short chase? I have to be honest. I get the alerts on my phone from your channel, and it's a default gonna watch. So I don't know. Was it a good chase or not? Thank you for being such a supporter of the channel. You really are every single time. And I appreciate it. I know behind the scenes you help me a lot as a bigger channel, helping out a little channel, and I appreciate that. So thank you, thank you, thank you. Jonathan has linked you. I can't imagine that you'll get very many subs from me, but if you do, you're welcome. Seriously, each and every one of you, I love you so much. So, so, so much.
Your Honor, I'm sorry, criminal trespass, en un domicilio.
Right. That is a Class A misdemeanor, which is punishable up to 1 year in the county jail and up to a $4,000 fine or both.
Ese es un delito menor clasificación A y la sanción posible para este tipo de delito es 1 año en la cárcel y una multa de hasta $4,000 o una combinación entre ambas.
The bail in your case is set at $8,000.
La fianza en su caso se puso en $8,000.
Do you want to request a court-appointed attorney?
¿Desea pedir abogado gratuito? Yes.
Okay. You also have a failure to identify yourself.
Además tiene una acusación de no haberse identificado apropiadamente.
That is a Class B misdemeanor, punishable up to 180 days in the county jail and up to a $2,000 fine or both.
Ese es un delito menor clasificación B con una sanción posible de hasta 180 días en la cárcel del condado, una multa de hasta $2,000 o una combinación entre ambas.
The bail on that case is set at $5,000.
La fianza en ese caso se puso en $5,000.
That's a total of $13,000.
Es un total de $13,000.
Do you have any questions about any of that?
¿Tiene usted alguna pregunta sobre esto? He shook his head.
Okay. Would you like us to contact any embassy or consulate to let them know you've been detained?
¿Usted desea que la embajada o el consulado de su país sea notificada de que usted está aquí en la cárcel? No lo oí.
Any other questions?
No. ¿Alguna pregunta?
No.
No.
Okay, who's number 2?
Leonel Castellanos Hernández.
Let's go ahead and get a quick vote. The other night when I was on Colin's channel, somebody said, "Oh, thank God she's not showing her tits anymore." Would you guys agree? Do you want me to stop showing my tits like this? Is this too much? Is this like, over the top? To me, it's perfect. It's a great amount. It's all boobs. It's great. There's no nips. The nips are down here. We're good. Well, I mean, they're like right here, but they're good. I mean, I was just shocked somebody said that in the comments. I laughed. You may not want to come by my channel because there is definitely more boobage than there was on Colin's channel. I actually thought I was being well behaved on Colin's channel. I was being quiet. I mean, I swore a little bit, but not that much. Oh, God. But I made the mistake of thinking, oh my God, there was 3,000 people that watched that live. Let's go see what they had to say. And then I read what they had to say and I thought, oh, Paisley, don't read what people have to say.
Leonel Castellanos Hernandez.
I'm seeing an Elazar Martinez Hernandez, but not.
That's one. That's my number 4. And I have Jose Garcia Osorio as well. Maybe they are showing it as Hernandez Castellanos? Castellanos Hernandez?
He's apparently on our next docket. I don't have his paper. Both dockets I thought were 1 and 2. I mean, I haven't been through docket number 2. I'm still going through it, right? Still setting.
That's why when we was out there, I said I was gonna bring both dockets. Like,
Well, I misunderstood. I thought you meant post 1 and post 2.
yeah, both 1 and both 2, all both dockets.
Okay. I have some of them done, but not all of them. I can run get what I've got done. I just am not through the whole thing yet.
All right.
Can you run and get what's in there and see if we've got him? Maybe I've looked at it. I don't know. Who's your third one, Rosario?
Jose Garcia Osorio.
Mikey, maybe you missed, there was some opinions on my boobs last night. They did not like them. Would you care to share your opinion?
Which docket is he?
Jose Garcia Osorio.
Yeah, we have Elazar right there in front of you. Do you have that one?
Yeah.
Read Elazar, okay?
Yeah, I can do him. We'll work on Elazar, right?
Okay, señor Eleazar Martínez Hernández.
All right, Mr. Martinez Hernandez, I'm showing you're charged. Let's see, it's a assault with bodily injury, family violence, Class A misdemeanor.
Señor Eleazar Martínez Hernández, muestro que tiene una acusación de agresión con lesiones corporales con violencia doméstica. Delito menor, clasificación A.
So Class A misdemeanors punishable up to 1 year in the county jail and up to a $4,000 fine or both.
Un delito menor clasificación A conlleva una pena máxima de 1 año en la prisión, en la cárcel del condado o una multa de hasta $4,000 o una combinación entre ambas.
This is out of Bell County.
Esto viene del condado de Bell.
Judge in Bell County set the bail at $2,500.
El juez del condado de Bell le puso una fianza de $2,500.
Thank you. Do you want to request a court-appointed attorney?
¿Quiere pedir abogado gratuito de oficio?
Sí.
Yes.
¿Puedo hacer una pregunta?
Yes. Can I ask a question?
Yes.
Sí.
Yo no soy, me están acusando, yo no soy él.
They are accusing me, but I am not him.
You are not that person?
¿Usted no es esa persona?
You need to speak with your attorney then.
Necesita hablar con su abogado de eso.
Do you want us to contact any embassy or consulate?
¿Desea que contactemos alguna embajada o consulado a nombre de usted?
Así está bien.
No le oigo.
Así está bien. Está bien.
¿Dijo que sí?
No, está bien. No,
No,
bien.
that's fine.
Okay, the judge has also issued, the Judd Bell County judge has also issued an emergency protective order.
El juez del condado de Bell también puso una orden de protección de emergencia.
Who is Joe Franklin Gonzalez?
¿Quién es Joe Franklin González?
Gonzalez, I need you to listen to this also. You also have a protective order that have been issued against you. So you need to hear these same things I'm about to say to you. The names will be different, but everything else. So this order in your case is going to protect Melissa Fernandez.
En el caso de usted, señor Martínez, la persona protegida a través de esta orden es Melissa Fernández
And Oscar Fernandez.
y Oscar Fernández.
You know them?
¿Los conoce?
No. You
No.
don't know them?
No los conoce. Hable claro, por favor.
No.
No.
Okay. So this will prohibit you from committing an act of family violence,
Esta orden le prohíbe cometer actos de violencia familiar.
committing an act of stalking,
También cualquier acosamiento,
communicating with either of them or any member of their household in a threatening or harassing manner,
además comunicarse con ellos o con algún miembro de su familia de una manera amenazante o hostigante,
going within 1,000 feet of their residence,
acercarse a menos de 1000 pies de su domicilio,
going within 1,000 feet of their school or childcare,
acercarse a menos de 1000 pies, ya sea de la guardería o de la escuela,
or possessing a firearm.
o la posesión o tenencia de armas de fuego.
You currently have a concealed handgun license, it would be suspended under this order.
Your Honor, you're saying that he does have a license or that if?
I'm saying if he has one.
Okay, I'm sorry, I just wanted to make sure. Si usted tiene un permiso para portar armas ocultas a través de esta orden, se le suspende.
Under the federal law regarding this, I can give you an opportunity to speak about this if you would like to say anything, but I want to remind you, anything you say can be used against you, and everybody in here would be a witness. So you may not want to do that. Do you want to say anything?
That's us too, ladies and gentlemen. We would also be witnesses to him speaking out of turn. When somebody, here's a great pro tip. Pro tip. If somebody says to you, are you sure you want to say something because you have the right to remain silent? Double check that and go ahead and fucking don't talk. Okay? Good idea.
Muy bien, de acuerdo con la ley federal, yo le podría dar la oportunidad de decir lo que quiera hablar, y usted puede hacerlo si lo desea. Sin embargo, debe recordar que cualquier cosa que diga podría ser utilizada en su contra, y aquí esto está siendo grabado y todo mundo podría ser testigo, así que probablemente no sería prudente. ¿Quiere decir algo?
Okay, this will last until midnight on November 20 on January 24th of 2024.
Esta orden estará vigente hasta la medianoche del día 24 de enero del año 2024.
Venti quattro. I can't say it properly. Venti quattro. I actually can't say it, you guys. Oh, fuck. Canada has gotten to me. I can't fucking say it.
They're also going to bring this over to you to sign that you've received this.
Además, le van a traer, le van a dar una copia para que usted la firme de esta orden.
Do you have any questions?
¿Tiene usted alguna pregunta? Señor Martínez, ¿tiene alguna pregunta?
Está bien. No.
That's fine, no.
Do you need this now? No, we shouldn't. The ones we've got. What? Okay. So who's your next person, Rosario?
I don't know. It's only 7:20 p.m., but oh dear. We're going late tonight, folks. Let's just get buckled in.
Either Castellanos Hernandez, I don't know if he's in the token, and Jose Garcia Osorio. I only have 4.
All right, I've got Lionel Castellanos Hernandez.
Okay, Leonel Castellanos Hernández.
Lisa, I was just thinking about our dinner that we had in Florida. How pleasant that was. It was so nice. The trio of what the hell is this? I think it's sour cream on the drink that I have. Guys, if you're not already subscribed to Iowa Backyard Cam, please go do that. She is close to 500 subscribers. We met in Florida. Honestly, I had salad. I'm admitting that. I had salad with chicken. First of all, I thought salad with chicken was pretty good. I'll just say it. I was meeting somebody I look up to. No offense, Lisa, but it was Mikey. I was a bit nervous, so I ate a salad. That's what I ate. I don't know what else to say about it.
Okay. You've got a motion to revoke your probation on an assault with bodily injury, family violence.
Tiene usted, señor Castellanos, un pedimento para revocar su libertad condicional por un delito.
He is our hero, and he was so lovely at dinner. Anyways, it was a great dinner. I wish I could have a redo where I get something that's not salad so that Mikey cannot laugh at me, but maybe next time. Hey, maybe next time.
Delito de agresión con lesiones, violencia familiar.
So Class A misdemeanors punishable up to 1 year in the county jail and up to a $4,000 fine or both.
Es un delito menor clasificación A y eso es sancionable con 1 año en la cárcel del condado, una multa de hasta $4,000 o una combinación entre ambas.
Bail in your case is set at $5,000.
La fianza en este caso se le puso en $5,000.
Do you want to request a court-appointed attorney?
¿Desea solicitar abogado gratuito de oficio?
Sí.
Yes.
Do you want us to contact any embassy or consulate?
¿Desea usted que nos pongamos en contacto con algún consulado o embajada?
No.
No.
You also have a third-degree felony, possession of controlled substance.
Además, tiene usted una acusación de delito grave de tercer grado por la posesión de sustancias reguladas.
That is punishable from 2 to 10 years in the institutional division at the Department of Corrections and up to a $10,000 fine or both.
Ese tipo de delito se sanciona con entre de 2 a 10 años en la correccional y una multa de hasta $10,000 o una combinación entre ambas.
The bail in that case is set at $10,000.
La fianza en ese caso se puso en $10,000.
Do you have any questions about any of that?
¿Tiene usted alguna pregunta sobre esta información?
Sí.
Yes.
What?
¿Qué?
La sustancia que encontraron no es mía. Yo voy a dejar a los muchachos allá a la cantina.
Hasta ahí. That substance that they are talking about, that's not mine. I took the guys to the bar.
Hey, remember, that's not a question, that's a statement. And that's things that you may want to wait and talk to your lawyer about, not to us here.
Bueno, recuerde que lo que está diciendo no es una pregunta, es una declaración. Y así que será prudente que espere hablar con su abogado sobre todo eso y no aquí con nosotros. That's fine.
Do you have any other questions?
¿Tiene usted alguna otra pregunta?
No.
No.
Okay, and Mr. Jose Osorio?
José García Osorio.
Okay. Mr. Osorio, I'm showing that you're charged with a third-degree felony driving while intoxicated.
Señor García Osorio, muestro aquí que usted tiene una acusación de delito grave tercer grado por conducir en estado de ebriedad.
That's punishable from 2 to 10 years in the institutional division at the Department of Corrections and up to a $10,000 fine or both.
Ese tipo de delito se sanciona con la reclusión de 2 a 10 años en el Departamento de Correccionales y una multa de hasta $10,000 o una combinación entre ambas.
Excuse? Excuse? What are you going to say, Judge? Tell us.
Your Honor, can you hear me?
Yes, I'm
Oh,
looking at this for a minute. Just give me a minute here. This is
yes.
one I hadn't looked at earlier.
Oh, okay.
Oh,
I thought I had frozen.
Nope,
I
you're
thought I
fine.
had.
Thank you.
Lisa, extra point if you can remember
The
what
bail on
kind
your
of
case is
salad
going
I
to be
had.
set at $12,000.
Seriously, what kind of salad did I have? What resort were we at? I guess we're not there anymore, so it doesn't dox us to say where we were. That was a lovely dinner. I still think of it fondly. I'll say that. What kind of dinner though? I remember everything I think that y'all ordered. We'll see. Miss Carrie knows, obviously. I mean, it's pretty easy to check, right? Like to think what you get. Chicken salad at Mikey's Hotel. That's right. We all stayed at different hotels. Let's be clear. Each of us stayed at different hotels. We walked there to get. In fact, Lisa, did we both walk further than Mikey did to get to that dinner? He didn't walk anywhere. He just came to us. Is that not right?
La fianza en su caso se va a establecer en $12,000.
You will also need to install an interlock ignition device within 30 days of being released from custody.
Además, se le va a requerir que instale un
Actually, Lisa, I have a video of me at the end of that dinner because I stole an umbrella. I stole an umbrella from that hotel to walk home to my hotel from. They were so smart. They were fine with it. I'm so smitten with Mikey. William, you got it. That's right. Duh. La duh.
un dispositivo interruptor de la marcha en el vehículo dentro de los siguientes 30 días de que salga usted de la cárcel bajo fianza.
Do you want to request a court-appointed attorney?
¿Desea solicitar abogado gratuito? ¿No lo oigo?
Do you have any questions?
¿Tiene alguna pregunta?
Do you want us to contact any
I would go with yes, Tin Man. I'm gonna say yes.
embassy?
¿Desea usted que nos contactemos con la embajada? I cannot see him though.
He said no.
Okay.
Yeah. That's everybody that you have a list of?
Yes, Your Honor, that's all. Do you want me to ask if anybody else?
You would, yeah.
Thank you. ¿Alguien más necesita que celebremos su audiencia en español? No takers.
Okay, sounds good. Thank you for your help.
Thank you, Your Honor. Happy Thanksgiving.
Thank you, you too. Excuse me for just. Okay, Mr. Gonzalez. I want to do yours next while this is still as fresh as it can be on your mind about the emergency protective orders. You've got two different charges. Both are second-degree felony aggravated assault with a deadly weapon and are family violence cases. These are punishable from 2 to 20 years in the institutional division of the Department of Corrections and up to a $10,000 fine on each case. The bail on each case is going to be set at $20,000. So that's a total of $40,000 bail, but it's $20,000 on each. On each case, you also have an emergency protective order that has been requested and presume will be granted.
Miss Carrie, are you are you calling me out on what you think I'm sexting on my phone? Shh. Girl, don't rat me out.
Are you familiar? Did you hear the things I was going over with that's required? Basically, no more offenses, no threatening or harassing contact, hand contact, but no threatening or harassing contact. And in your case, it would be not within 200 yards. What's the address? 21951 and Shower Drive. Is that right? It's my house. You can't go there. You cannot go there until this expires or unless it is changed by another judge. Your family can't change this. You make up and it all works out and you want to go back, you go back there, you can be arrested for brand new offenses for violating the judge's protective order. So you need to have it changed by a judge, or you need it to expire before you can go back to that house. Got it?
Miss Carrie, I have a secret lover that I'm not allowed to talk about that is not my baby daddy. Let's just put it that way. I've said too much.
You need something from there, somebody needs to bring it to you or go get it for you. It's to create an area where the people that were the alleged victims of this have a safe place to be. Do you have any questions about this? I need to give you an opportunity to say anything as well. But again, I want to remind you, anything you say can be used against you in court. Okay. Talk to your lawyer about it is the thing to do. Sorry?
I'll say that he might be watching, he might not. I'll leave it at that. He may or may not be. He is definitely not on the screen ahead of you. I'll put it that way. Thank goodness my lover is not on the screen right now. We'll put it that way.
Yeah, I can mark down court appointed on each case.
You guys are making me laugh. Secret love man. Secret love man. He might leave because I sang, you guys. Please don't ruin my relationship yet. I don't need him to know that I can horribly sing or that I desperate. God damn it. Loud Elvis, are you calling Mikey Michael? Because I'm not sure that I've heard that before. Are we talking about Michael? The legend, Michael. Dana, are you talking about the guy that I'm talking to? He's a lucky guy. You're so sweet. Love it. I'll tell him. I'll tell him you think that. Also, can any ladies out there that have long hair teach me how to do my long hair? I have such long hair and I don't know how to do it, and I want to do those like things so that when I get off the plane, my hair is just like beautiful. Can somebody message me about that, please? Because TikTok has not been helping me enough. I've been trying to learn.
It is possible to get that changed, but that's something you'd want to go likely with the alleged victims to the judge in whatever court you end up in, or back, you can come back to one of the municipal court judges as well, if it's not indicted at that point. Do you have any questions? Okay. Junius Harrell. Mr. Harrell, charged with a first-degree felony. Is it manufacturing or delivery of controlled substance. So that's punishable from 5 to 99 years or life in the institutional division of the Department of Corrections, and up to a $10,000 fine or both. The bail in your case is set at $30,000.
Mikey, do you sleep well in your bed at home? You're glad to be back from your daughter's house, but do you sleep well there? Or is it just like, okay? Because, I've slept in a couple beds. Generally, it just depends on who the person is that I'm sleeping with, how well I sleep. If I sleep like amazing, it's usually because I'm with somebody pretty amazing. But maybe you just sleep that way in North Carolina all the time. Wait, your daughter lives in North Carolina too? So it can't be North Carolina. What is it? What is it that makes it so nice to sleep in your own bed? Tell us. Lisa Figalicious, you're from Arkansas right now? Arkansas? Is that what they call it? Arkansas. Hello, Lisa from Arkansas. Your man T-Rex was here earlier saying hello. Where's Lisa? Where's Lisa? I sleep. This couch that you see right here. That's my humble abode because I'm lonely and I don't like to sleep by myself. And so when I sleep on a couch, it feels like I'm sleeping with somebody else. Okay, that's sad. Let's keep watching court.
You want to request a court-appointed attorney? Yes, no? Sorry? Guess the weight that they measured it at was a first-degree felony weight. Well, okay, well, talk to your attorney about it. I mean, that's what it's saying here. Do you have any other questions? Emmanuel Niembro?
Did he just say bullshit?
Mr. Niembro, you're charged with a Class A misdemeanor driving while intoxicated. So that's punishable from 30 days to 1 year in the county jail and up to a $4,000 fine or both. The bail on your case is set at $5,000. In addition, you will need to install an interlock ignition device within 30 days of your release on your vehicle.
What about if I don't get the car one, do I get the purple one?
If you what?
If I don't get the car one, do I get the purple one?
You don't get the car.
If you don't get the car installed, can you get the portable one?
No, you'll need to get it on the vehicle.
Yeah, because my vehicle is used, so like there's no need for me to like it's still, so I'm not gonna go get it.
Well, you can talk to the
I get it done.
you can talk to the people on the that set this up. Maybe they can work with you on that. And your judge in the court you're set in could also change that.
Sorry, Mikey. Why would you guess that Colin had me on yesterday? Did you watch? People complained about my tits being out, about me being a Karen, the things that you say you love me for. What tipped it off? Tell us. Tell us now.
But right now it's going to be set on your vehicle. Do you want to request a court-appointed attorney?
Okay.
You'll get your own?
Yeah, I can still change it at the end, right? Towards the end.
I'm sorry, what?
Yep. Yeah.
Any other questions?
Just the bond part. How do I do that again?
You can post $5,000 in cash. You'll get it back as long as you show up and get your case resolved. You can hire an attorney or a bondsman to post a $5,000 surety bond. You can apply for a personal bond. Apparently you already did. You've actually, they've already recommended that you get a personal bond. And I've already signed it. So you'll be being released after this once they can get to you and get you released. Right. Andre Hayward. Mr. Hayward, let's see. Mr. Hayward, you're charged also with a Class A misdemeanor driving while intoxicated, also punishable from 30 days to 1 year in the county jail and up to a $4,000 fine or both. The bail in your case also set at $5,000. You also have an interlock ignition device that's going to be required. Yours is actually required by December 9th, 2023. December 9th. Judge Thomas.
December 9th, 2023. Funny enough, last day that I will be streaming before I take my once a year break for that week for 5 days. So just keep that in mind if you're going to be sad about it. December 9th, 2023 to December 15th, 2023. Be on break. Don't tell anybody. It's okay. It'll be fine. YouTube Daddy doesn't need to know.
Did yours early. He put a date on it as opposed to a 30-day from your release. So you'll need to have it installed by December 9th. So check with them immediately as soon as you get out of custody. Do you want to request a court-appointed attorney?
Do I have an option to hire one or choose?
Yeah, obviously you can always hire one. If you want to choose your own attorney, you can hire one. You can request a court-appointed at any time.
I'll hire.
Yours also, they've also recommended a personal bond, and I've also approved that and signed that. So you should also be being released as soon as they can get to that once they get you back from here.
Okay.
Any other questions?
Well, I want to find out the difference between hiring a court appointed as hiring an actual attorney as opposed to court appointed as a elongated.
Well, they're both licensed attorneys. The difference is going to be you get to choose your attorney versus you get whoever is on the appointment list and the next person in line when they get to your deal. So if you want to get your own attorney, you need to hire it. You also need to qualify. I mean, if you don't qualify, they're not going to give you a court-appointed attorney anyway. So, Anthony Beckham. Mr. Beckham, you're here on a 3rd-degree felony possession of controlled substance.
Hold on. HR got my vacation requests. I'm going to be there regardless if anybody wants it.
That's punishable from 2 to 10 years.
I'm Canadian. We get 2 to 4 weeks generally the first year, so don't you worry about it. My vacation request is approved.
In the institutional division at the Department of Corrections, and up to a $10,000 fine or both. Your bail is set at $8,000. Do you want to request a court-appointed attorney?
Yes, sir.
Any questions?
I applied for a first one.
Sorry?
I said I applied for a first one.
Yeah, yours has also been approved. I've already signed it. You should be being released as soon as they can get to everybody that's being released.
I appreciate it.
Dion Brown. There, Mr. Brown. Mr. Brown, looks like you have 3 different cases. Get this. You've got a Class A misdemeanor possession of marijuana. That's punishable up to 1 year in the county jail and up to a $4,000 fine or both. The bail on that case is set at $1,000. Do you want to request a court-appointed attorney on these cases?
Yes, sir.
Any question about that one? Any question about that particular case? You've got 2 second-degree felony possession of controlled substance cases. Those are going to be punishable from 2 to 20 years in the institutional division at the Department of Corrections and up to a $10,000 fine on each case. Each of those cases has a $15,000 bond. So you've got 31,000 total. And I'm going to mark that you're requesting a court-appointed attorney on them. Any questions about all of that?
Yes, sir.
What?
If it wasn't in my possession, how am I charged?
Okay, again, that's not a question, that's a statement, a fact, making everybody witnesses in here. You want to talk to your attorney about things about your case. If you have questions about how to get out of jail, or you have questions about pre-trial.
That was a question. It's all right. It's cool. That was a question.
Okay, well, you can ask the question if you want, but the first thing you said was it wasn't in my possession. That's a statement.
Say if it wasn't on your possession.
If it wasn't.
Car wasn't yours.
Okay.
You got the car. And I got arrested and charged with things that wasn't on.
They've got to prove it. It's their problem. They have to prove that you had possession of it.
If you'd be able to see that it wasn't in my possession, cameras, that nothing was on me, how can it stick?
It may or may not. I don't know if it will or not. I mean, there's reasonable suspicion for them to have gotten to it and probable cause to believe it, but they have to prove it in court beyond a reasonable doubt. Those are totally different standards, much more difficult to prove beyond a reasonable doubt. And that's what your attorney would be able to do. Any other questions?
30,000, how much is that 10%?
Well, 10% of 31,000 would be 3,100.
That's it.
30.
My car was hit. I'm be out. Yeah, I'm good.
Okay.
I'm good.
Scallion.
Yes, sir.
Mr. Scallion, you're here on a Class A misdemeanor driving while intoxicated, again punishable from 30 days to 1 year in the county jail and up to a $4,000 fine or both. Bail on your case is set at $5,000. Do you want to request a court-appointed attorney?
Yes.
Any questions?
I applied for PR bond.
Yes, you have also qualified for a personal bond. I've also signed that. So you should be being released as soon as they can get to everybody after. Charles Miller. Mr. Miller. Okay, so Mr. Miller, I've got 3 different cases here. One is a local case for failure to maintain financial responsibility, no insurance while you're driving. That's going to be reset at Austin Municipal Court on January 29th at 2:30 p.m. in courtroom number 4. We'll get a copy of that, and that's to appear. The thing that can help you with that, if you'll show up and have insurance, have a driver's license, have insurance, all that can be legal at that point. Great. And if you had it at the time, you need to bring proof that you had it at the time. And if so, they'll dismiss the case. You've got 2 cases, it says one out of Williamson County that is a second.
Tin Man, I am gonna take that as a fucking compliment. Did you just say this is the weirdest chat? I'm moving a mouse that doesn't have a battery in it. Presto, we did miss you. Thank you for being back. What happened in the last 5 minutes? Come on. Am I going to Disneyland? No. I wish. I'm going somewhere better that I can't talk about. Seriously, Presto, we've been missing you. I've been talking about you. The channel's monetized now. I noticed your name is not green. I mean, I guess that's okay. But no, I have been fucking talking about you lately. Have I not, people? I even said, if we say Presto's name enough times while we're watching a Clayco case, he will show up. And yet you didn't. You disappointed me. You literally fucking disappointed me. I'll say that. Seriously, we got monetized while you were gone. Thanks for noticing. Become green. Seriously, you I'm not even gonna repeat that. Seriously though, look around. I've been working too, even though my family thinks that every single one of you is fake. I just want you to know that. I talk about y'all at dinner sometimes. I say, hey, Beverly said this, Vicky said that, Nancy said this, Jonathan said that, Lisa B said this, Loud Elvis said that. Streamlabs. Ugh, that loser. And you know what happens? They say, Paisley, should we get you a 5150 hold? And I say, no, that doesn't exist in Canada. You shan't. And they say, no, but seriously, are you okay? Are those real people? Because, like, I don't think they are. And I say, I swear to God, they are. Each and every one of them like my videos. One day, it'll be easy to prove it. I swear to God. I swear to God. I will keep working. I will keep posting almost every fucking day for the next 5 years. And when I get my 100,000 subscribers plaque, I know that's way far away. I'm not even at 1,000 yet, but it's on the horizon. Y'all can be free 1,000K on that channel, and my family cannot. Let's just put it that way.
Second-degree felony indictment. Does it say what for?
POCS.
Yes, POCS. So that's punishable from 2 to 20 years in the institutional division of the Department of Corrections and up to a $10,000 fine or both. The bail in that case set at $25,000. You want to request a court-appointed attorney. You also have a probation violation on an evading arrest and detention with a vehicle out of Lee County. Because it's a probation violation, they've issued a no bond on it, so they're going to extradite you, they say to that. So they're going to get you up there to resolve the case, unless your attorney can get that changed to where they would agree to issue a bond or agree to release you to appear or something like that.
How long does that take?
Well, if you're being extradited, it's usually 10 business days, but you're going to have to resolve the case here before they're going to be eligible to extradite you. The insurance, I don't know what they'll do with Williamson County, because Williamson County is right around the corner. They may take you there first to resolve that one.
Presto, can you do me one solid? Turn on gifting on the channel, please, because YouTube Daddy was being so mean earlier, and you know how, like, when daddies are mean, that's like so mean, and I don't deserve that. So just like turn on gifting, and then YouTube Daddy won't be mean to me. Okay? Thank you.
And you can hear them, please.
Yes, Your Honor. Señor José Chávez, ¿me puede escuchar bien? Señor Leonel Castellanos Hernández, ¿me puede escuchar bien?
Sí.
Señor José García Osorio.
Sí.
Señor Eleazar Martínez.
You should also be being released as soon as they can
start
get
over
through
again.
that once they get you back from here. Okay. Any other questions?
Well, want to find out the difference between hiring a court appointed as, hiring an actual attorney as opposed to court appointed as a elongated.
Well, they're both licensed attorneys. The difference is going to be you get to choose your attorney versus you get whoever is on the appointment list and the next person in line when they get to your deal. So if you want to get your own attorney, you need to hire it. You also need to qualify. I mean, if you don't qualify, they're not going to give you a court-appointed attorney anyway. So, Anthony Beckham. Mr. Beckham, you're here on a third-degree felony possession of controlled substance.
Whoa, we've heard Mr. Beckham. Hold on. Did you, I don't know if you saw what just happened there. I don't know what just happened there. We're scrolling ahead. Here we go. Also, is this guy sleeping right here with his arms crossed and his head over like that? Seriously, is he sleeping?
On the 13th, I haven't been in any trouble getting on in 2 years.
Okay. Well, I would talk to your attorney is the one who's going to be able to help with that in each place, whichever attorneys you have in each case. Those are the ones that are going to be able to work with or work with the prosecutors on those cases.
So, okay, so right now, I don't, I have to work on it. So when I don't get a talk to them, but like.
They should, if it's approved, they should contact you within 48 hours on a felony. That's 48 hours of them getting the appointment, and that probably won't happen until tomorrow because this is a holiday. So, I mean, yeah, but they work. I mean, they're on holidays they don't, but on regular weekends and days they do. That's okay. And I don't know all the answers either. I'm just telling you the best I know right
Have a place, and I was trying to see what I can do to get out and save
now. Okay, Mr. Jenkins.
RC.
Who's that? Yes, RC. I'm sorry. I thought you were finding him. Okay, Mr. RC Jenkins, is that right? Okay, you can sit down. Okay, so Mr. Jenkins, you're here on a third-degree felony possession of controlled substance. That's punishable from 2 to 10 years in the institutional division of the Department of Corrections and up to a $10,000 fine or both. The bail in your case is set at $15,000. Do you want to request a court-appointed attorney?
That was set.
$15,000.
So I didn't qualify for the PR.
You weren't recommended for a PR. Pretrial service does a background check and they recommend or not. Your attorney may be able to talk to a judge and see if they can convert it to one, but you're not going to get one right now. You want to request a court-appointed attorney? You want to request a court-appointed attorney?
No, I haven't.
Okay.
I'm gonna call them.
Do you have any questions? I'm sorry? Okay, do you have any other questions of me? Okay. Jonathan Leake. Where? Mr. Leake. Mr. Leake, you're here on a second-degree felony possession of controlled substance. So that's punishable from 2 to 20 years in the institutional division and up to a $10,000 fine or both. The bail on your case set at $15,000. Do you want to request a court-appointed attorney? Do you have any questions? No? Mr. Lopez. Joe Lopez there. Mr. Lopez, also here on a second-degree possession of controlled substance, again, 2 to 20 years in the institutional division and up to a $10,000 fine or both. Bail in your case is also set at $15,000. Do you want to request a court-appointed attorney? Yes, you were, actually. You'll have to qualify, so being out is less likely that you'll get one, so you may want to start interviewing attorneys as well. What was your name? Doesn't look like it. I would have marked it on the front if so. No, you were not recommended for that. History of the same, and they were unable to verify your address. So pretrial is not recommended. Your attorney may be able to again get that turned around, but right now you're not being recommended for that. Question? Can't hear you. Sorry, got noise. I can't hear you. It's the amount of the weight is what puts it one place or another. I mean, that's the kind of thing that you'd end up in a pretrial hearing or in trial to be doing. Yeah. Question?
Yeah. They see $9,000 of mine. I'm trying to figure out what do I do. I fight for it. They ain't telling me nothing about my money. They see $9,000 and tell me nothing about it.
I'd talk to your lawyer. I mean, lawyers are the ones who do stuff at this point.
Oh, yeah, I just got it. He ain't gonna know nothing, man.
Yeah, I'm telling you about rights and bail. That's what we're talking about here. Not about your case. You're gonna have to talk to your lawyer about it.
Yeah. You can't answer nothing. This is just, he was here to tell you how to get out. That's it. That's it.
These are the ones I still need to go through. I can do them one at a time, or do you wanna?
It's up to you.
I mean, if you want, I'll sit here and do them, or if you wanna take some of them back and hang on to the ones that are here, I can do that. I can give you the list of who I haven't done. And I think they'd be all on that second list. They should be, because I'd done that whole first list. I've got Martinez. Wait, yeah, I don't have them in those orders. You have alphabetical? Oh, great. Okay.
The ones I wrote bonds on, I'll keep those.
Okay. If you want to start doing that, and I'll start working on these, then we can do whatever's left once.
How many do you have?
Did you bring everything from the desk? I've got 1, 2, 3, 4, 5, 6, 7. I've got 8 persons, but more cases because some of them have multiple cases.
I'm just gonna get everybody back up and we'll run those cases upstairs.
Sorry. I just didn't understand what you were saying when you said that. I wasn't through the second one.
You get it 2 o'clock.
Not exactly what I was looking for. Go into
innovations. That's why I'm here today. We're starting with
That's not even close to what it is. I do have one last clip, one unprofessional shit show. Miss Carrie, I love you so much. I know you mean that in literally the most literal way, and I appreciate it. I have one more show to show us. It is a 11-minute clip of child support contempt, and then we're done. Guess what? We've been going almost 3.5 hours. I've been avoiding reality for 3.5 hours. Can't be avoided forever, apparently. Don't tempt me to find something else. I will sell you like yoga pants.
Okay. All right. Good morning. Can you hear me okay?
Yes, Your Honor.
Great. So I think we just have one matter this morning, 223-0011908.
Are you expecting Ms. McNeil to be here, Mr. Angelica?
Yes, is she in the waiting room?
She's not. Let me take another look. I don't see her yet. If we're expecting her, we can wait a few minutes.
I'll defer to you, Mr. Angelica.
She sometimes has issues with connecting. I'm going to mute Your Honor and see if I can reach her by phone.
Okay, sounds great.
Oh, Jay from Michigan, you understand what gets me going, which is immediate gratification.
So address, and I may have missed it, alternative solutions contact.
She contacted them, Your Honor. She gave the name of the person and I emailed that over. She contacted and spoke to Emily. Trying to find the name here.
I believe it's Johnson.
Yes.
She's their full-time staff member who does the intake calls and screenings.
And Ms. Johnson indicated their computers were down and that she would call Kayla back in the afternoon. So she was required to contact them, which she did, and hopefully they will contact her back and provide some direction as to where she could get other services. I know she does have by the KCI Institute a letter, and I'm well aware of the fact that her eye issues were due to type 1 diabetes. So she does have type 1 diabetes. She had been having some health issues from that recently with edema issues and some other things that were happening in regard to her diabetes. But, after the eye operation, she was pretty much almost legally blind prior to the operation, but I think she did well in the operation and is recovering.
Okay. So Ms. Looney, what's the request on behalf of the state? I'll note she was here at the last hearing. We'll certainly note the FTA for today. And I think on the October 4th hearing, she was not present. But go ahead, Ms. Looney.
Thank you, Your Honor. So at this point, we would just be asking for the next review hearing to be set for December 27th. And at that hearing, we would ask for an update regarding the mental health, whether or not she's got that appointment and if it's been completed. If there's documentation of that, we would request the evaluation outcome. We would also ask for another monthly compliance report from her substance use disorder treatment center to ensure she's continuing to be in compliance and making steps forward. And we would ask for a monthly job search and work log, which would include counseling or treatment appointments, any contacts she makes with alternative solutions to facilitate additional services and assistance would also count towards those hours. And we are encouraged to see that she's making some positive steps forward and hope that she continues on that path.
Okay. Mr. Angelico, any objection to setting this to December 27th with the requests of the state?
No, Your Honor, somebody will be covering on the 27th docket. I'm not expecting to be in state.
Well, good for you. Okay. Hopefully you don't get trapped somewhere in a snowstorm.
Well, that's happened before.
I know I debated against traveling to the East Coast for the holidays for that reason. So
We're going south, so it shouldn't be too bad, but we have in the past, because of snow in the Dallas area, got stuck for about 3 extra days.
right. And you would not expect that going south. So
It's stuck being with grandkids, so
well,
wasn't horrible.
well, I think in full disclosure too, Mr. Angelico and I were both we ran into each other a few months ago at the Seattle airport due to flight delays. I was coming back from the East Coast and you must have been coming up from the South.
From Texas.
Yeah. So, all right. Well, better luck this time around.
Yeah.
Oh, thank you, Judge. I am also flying out of the Seattle airport sometimes, and yeah, it gets sucky around there. Is this seriously like privilege at its utmost? These judges and lawyers talking about which airports they might meet each other in? I don't know. Let's see. We're almost finished, guys. We're 3.5 hours in. I wish I could longer. I could, but I'm not gonna.
Maybe travel a different airline other than American. We ended up on Alaska because of issues with American delay.
Well, we were flying Alaska and still ended up with the same issue the whole way. So, yeah. All right. Well, happy Thanksgiving to you both. We'll see you next week.
Thank you. And I'll let Ms. McNeil know what occurred today.
Well, evidently I had way less time than I thought I did. But you know what, ladies and gentlemen, like I said, this has been over 3.5 hours. I appreciate each and every one of you being here. It's been a lovely evening. I know Thanksgiving was last night for a lot of you, which means today is an extra holiday, and I want you to take it as such. Go and seize the day. Have a good time. Make love to your partner. Make love to yourself. I don't know. Do whatever makes you feel good. Anyways, please remember that I love you, I'm proud of you, and I will see you tomorrow. I love you. Bye. Oh, yes. For any of you that noticed, that was Larry Beaver back from rehab, ready to prove himself to us. Just wait. Bye.